So it looks like we're live. So good morning, everyone, and welcome to this session of the Joint Standing Committee on Health and Human Services. This is both an information session this morning as well as some language reviews. And this afternoon, it'll be a number of bills that we'll be working in work session. You can watch us on the YouTube channel by going to the legislative website and looking for the committee's drop-down, choosing HHS, Health and Human Services. Everything we do is recorded and available for later viewing if you can't stay for all of today. We regularly have technical problems, some on our end, some on yours, some in who knows where, but we count on those. And if you'll bear with us, we'll get through them. We have so far been very successful at that. So let's go ahead with introductions, and I'll go over some of the other details when we're likely to have people in the work session. So with introductions, can we start with Representative Zager?
Thank you, Mr. Chair. Good morning, everyone. I'm Sam Zager. I'm honored to represent District 41, which is part of Portland.
And Representative Lemelin?
Good morning, everyone. My name is Michael Lemlin. I represent House District 88, Chelsea, Jefferson, Whitefield, and half of Noblesboro.
Representative Griffin?
Good morning, everyone. My name is Abigail Griffin. I represent House District 102, which is Glenburn, Levant, and Cadescate.
Representative Craven?
Thank you, Mr. Chair. Good morning. I'm Margaret Craven, and I represent House District 59, which is part of Lewiston.
Representative Madigan?
Good morning. Thank you, Mr. Chair. I'm Colleen Madigan. I represent House District 110, which is part of Waterville and part of Oakland.
Representative Perry?
Good morning. I'm Ann Perry. I represent House District 140, which includes the communities of Indian Township, Baileyville, Barron, Calais, Charlotte, Robinson, Perry, Pembroke, and Pleasant Point.
Representative Javner?
Good morning. I'm Representative Kathy Javner, and I represent House District 141, which is located in Penobscot and Washington County.
And Senator Moore?
Good morning. I'm Marianne Moore, and I represent Senate District 6, which is all of Washington County, as well as Goldsboro, Winter Harbor, and Sullivan in Hancock County as well.
Representative Meyer?
Thank you, Senator Claxton. I'm Representative Michelle Meyer, serving Southern Maine's District 2, which is all of Elliott and parts of Kittery and South Berwick.
And I'm Ned Claxton, honored to serve the folks in Senate District 20, which consists of Auburn, Minot, Mechanic Falls, Poland, and New Gloucester. Our staff is here with us today, and we're lucky to be able to work with them. I'd ask Anna to introduce herself.
Hi, I'm Anna Broom. I'm one of the legislative analysts for this committee, and I work in the Nonpartisan Office of Policy and Legal Analysis.
And Sam is here.
And my name is Sam Senef, and I'm the other OBLA analyst.
And our clerk is Karen.
I'm Karen Thomas, and I'm the clerk for the Health and Human Services Committee. If you need assistance, please email me at hhs@legislature.maine.gov. Thank you, Senator.
In reviewing some letters for some work we have to do tomorrow, I noticed our letterhead doesn't include Luke Lazur as part of the staff, and that seems like a oversight, but too bad he's not listening. All right, so this morning we're going to have an informational session briefing, and we are here to welcome Attorney General Fry, or yes, he is here, and so we'll welcome him in. And he's going to update us on opioid settlement information as it continues to evolve. Welcome, Attorney General Fry.
Good morning. Did I make it through?
You did. You threw the wormhole.
Well, good morning to you. And I appreciate this opportunity to be back with the committee and to talk a little bit about some stuff that I was not in a position to talk about when we last met about these opioid-related litigation settlements that we've engaged in with Johnson & Johnson, AmerisourceBergen, Cardinal Health, and McKesson. So I'm going to try to pick up where I had left off before. As folks may remember from my initial presentation to the committee, we were looking at a not insignificant amount of money over an 18-year period as a result of these settlements that would be directed towards the purposes of opioid abatement here in Maine. And there were different parties that were involved in this litigation. On the plaintiff side, there was the state of Maine, political subdivisions, and school districts that had litigated against these entities. And so when I was last here, I couldn't confirm for the group that there had been agreement that would allow for these settlements to conclude with the opioid manufacturers, distributors. And so as you may all know, or as you may all have guessed since I'm back, there was an agreement that was reached specifically between my office, state of Maine, political subdivisions here in Maine that are involved in this litigation. There's two different types of political subdivisions involved. One, those counties and cities that sue directly, and two, those counties and cities that did not sue but have more than 10,000 individuals for their population. So as an example, the town of South Portland did not file its own suit against these defendants, but South Portland has more than 10,000 people. So South Portland is an example of one of those that would be a non-litigating political subdivision that's involved in this settlement. So that was the second group that we had to reach agreement with. And then, of course, the school districts. So an agreement that was reached by these three different groups paved the way for acceptance of the settlement terms by all parties, really making it so that Maine should be in a position to receive the full amount of resources from these settlements with Johnson & Johnson, AmerisourceBergen, Cardinal Health, McKesson. We should meet all the bonuses that we're supposed to meet. We had the maximum participation that we needed to reach. So that will be good for Maine in terms of our accessing all the resources available to the state and to its citizens. This agreement between, again, the state, the political subdivisions, litigating school districts, it involves a few different terms. I'm going to hit on those. I expect there will be questions. And so I guess I'll ask the chairs, should I go term by term and then ask for questions, or do you want me to just run through the terms?
Why don't you run through the whole thing so we can get the big picture, and then people can keep track of questions as they come up.
Perfect. Thanks very much. So the resources are going to be directed here to the state, and there's a percentage that's attached to how these funds will be distributed. First, 20% of the total amount will come into the state through the Office of the Attorney General. That is common for these types of consumer protection type actions. There's actually an account that is set up to receive different consumer protection related funds. I believe the committee is probably familiar with that fund. So 20% would be directed to the OAG to then be able to be used, again, specifically for opioid abatement projects. 30% is going to be directed to the political subdivisions who are, again, those were the litigating and the non-litigating over 10,000 in population. So 30% of the total state proceeds will be directed specifically to those cities and counties to be spent on the abatement related purposes outlined in the overall settlement. And then 50% of the total amount coming into the state will be put into a fund that is to be managed, if you will, or the funds will be distributed through a recovery council. And so this is it's a general fund. It's a fund that's going to be able to be applied to for various abatement projects across the state. Projects that may come from the executive branch, may come from the legislative branch, may come from a political subdivision, may come from, entities that are active in abatement across the state. 50% of this proceeds are intended to be available for those different purposes, right? So we'll call it sort of a more generalized way in which monies can be spent on a range of important abatement projects across the state. That 50% is at least under this agreement would be managed by a recovery council. So you may remember some discussion when I was last before the committee about how the plan for this was to bring in that range of voices that are really important for a comprehensive distribution to confront the opioid crisis that continues to be on fire here in the state. And so a recovery council that was set up by this agreement would balance voices that I think are important to this. So there's 11 members that have been designated, 4 that are from state positions. So 2 from the governor's office, and then 2 directly from the legislature, 1 appointment of the Senate president, 1 appointment of the Speaker of the House. There'd be 4 that would come from political subdivisions. So the political subdivisions, they would need to get together, come up with their own representatives to this recovery council. And then 3 from, more generally from the public, that would be appointed by the Office of the Attorney General. And in particular, those public members would have to be pulled from among the following populations: individuals or family members who were impacted or who are impacted by the opioid crisis, individuals with substance use disorder and recovery community experience, and 3rd, public health experts in treatment or prevention. So the goal of this 11-member composition was to provide a range of perspectives, insight, that are active in the discussions around how to address the opioid crisis and this addiction crisis, with relevant information. Additionally, no one group has all the power. So to the extent that the state actors get together and say, we want to do something, they would have to pull some votes from either the political subdivisions or from the public members. Again, the idea being that it provides for a balanced approach to, what is it that is appropriate to address the crisis? Let's direct the money that way. I did want to make sure that the legislature had its own opportunity to include voices that perhaps, if the thought was not enough attention was paid to a certain community, or not enough, there did need to be a stronger voice someplace. So in addition to the 11 established members, this agreement contemplated that the legislature could add up to 4 members to this recovery council. So if the legislature wanted to add folks from the treatment community, add folks from the recovery community, add folks from the legislature, add folks from the executive branch, this agreement contemplates that the legislature could add an additional 4 individuals. So I just wanted to highlight that. This council, at a minimum, would meet twice a year in order to do its work of considering proposals, determining how to direct this money out. Quite frankly, I think that it's going to be meeting more than 2 times a year. But there is that minimum. There are terms for how the Recovery Council will set up its own bylaws to direct how it's going to do its work. It will be supported by the legal support will come from my office. So some of the folks some of the folks in my office who've been working on this litigation for years, who have a good sense of what it is that this litigation was aimed at addressing. They'll be providing legal advice to support to support the Recovery Council. There was no administrative cost that was directly built into this, so my office is going to be bearing that cost, certainly at the front end. But the agreement does contemplate that the Recovery Council may decide that it needs a greater level of administrative support, and if the council so chooses, could direct some of the funds to provide support for its work. Transparency was contemplated. Transparency is terms were built into the agreement, so it's recognized that not only is this work important, but making sure that there's a public accounting for the programs that are being supported, the work of the committee, and where the dollars are going. It was all anticipated by this agreement that would be available. And then let me add one more thing. So I as part of this 50%, and this was part of the agreement specifically with respect to the school districts, because you didn't hear me mention any school district representation on the council. School districts are involved in this agreement. There was a specific percentage that is to be directed towards statewide special education spend to be decided by the Recovery Council that would address the concerns that were raised by the school districts in their own litigation. That's a minimum. Certainly, it can be more, but as part of this agreement, it could not be less. And then, in addition, I also want to highlight that the legislature, of course, could add more members. It is contemplated both by the legislative representation on the council, but also recognition that there will be legislation that looks at the fund as a place that might have resources available to support opioid abatement activities. And so this agreement anticipates that it would be appropriate for those bills that impact the fund to be specifically considered by the HHS committee. Of course, this agreement can't make the legislature do anything, by the way, just to be clear, but it anticipates that relevant legislative committees, HHS and of course appropriations, would play some role in helping to identify appropriate programming, and then provide that vetting for projects that may, or programs that may come from the legislature. And then I think finally, before we get to questions, the really last big term had to, and this is what led to, this was really the term that took us up to the end. There are private attorneys who have been involved in representing the political subdivisions that sued directly, as well as attorneys that were representing private attorneys that were representing the political subdivisions. With respect to the private attorneys for the political subdivisions only, there is some amount of money that's going to be available to cover attorneys' fees through a national pot. And so there's a common benefit fund where those private attorneys who engaged in this litigation across the country, representing counties, municipalities, some private attorneys who represented states, because there are some states that use private counsel to represent them. They may be able to access this common benefit fund. There's about 1.6 billion that was set aside for this purpose nationwide. And the two different types of applications they can make are if private counsel contributed some common benefit to the overall litigation that occurred that led to the closing of this settlement. They may get some money recognizing that for attorney's fees. The second one is contingency fee related. Private counsel can apply and say, look, we have these contingency fee agreements. This is what we would have gotten under our contingency fee agreements. We'd like to have this paid out by the national pot, holding our clients harmless from that. So these private attorneys need to go under this agreement with the political subdivisions in particular. They need to go access as best they can the Common Benefit Fund, consistent with what states and territories across the nation did. There is a backstop that was built into this agreement. And what this backstop is, if private attorneys, they apply to the national pot, they get so much money, but there's a difference between what they got from the national pot and what they would have otherwise received under their contingency fee agreements with the litigating political subdivisions. There's a small pot of money that comes only from the 30% political subdivision pot that may be available to make up some of that difference. If it's necessary, make up some of that difference between what the private attorneys get at the national level and what they would have otherwise gotten if they enforced their contingency fee agreements here in the state of Maine. I want to emphasize, though, that money does not come out of the 50% that I just described is going to be anticipated to be spent by the Recovery Council. It does not come out of the money that comes to the OAG. That money only comes out of the political subdivision pot. And there was a cap. There was a cap in particular on how much can come from the political subdivisions. So I think those are the key points. I'm sure there's a lot of details that I didn't hit on, and happy to answer any questions that this generated.
Thank you, Attorney Fry, for that update. Yes, Senator Moore.
Yes, thank you so much for the update. I'm definitely trying to write as fast as I can. Will we be able to get a copy of the settlement?
Yep. Yeah, so there's going to be two different, I'm sorry, Senator, I interrupted you.
No, go right ahead. That's what I said.
There's going to be probably two different things to refer to, right? So first, yes, on the settlement, I do have that posted on the Office of the Attorney General website, but I can, as soon as we get off, if she hasn't already, I'll make sure Anna Brome and San Senef get that link from me to share with the committee. In particular, there's two different agreements that pertain to what I just described. One, and this is one is going to be called MOU with political subdivisions. The second is MOU with the school districts. So I'll make sure you get that. And in that, not only does it have the agreements, it has some relevant attachments or exhibits that I think are also important for consideration, that include, the range of activities that these funds are anticipated to be spent on, right? Those abatement related activities. But it also has a list of all and I know this was an interest of the committee, a list of all of the political subdivisions that were involved in this litigation as an exhibit, so that everybody will know exactly who it is that's a part of this.
Do you have a follow-up, Senator Moore? Did you get your questions answered? Okay. Representative Perry.
Yes, thank you. Actually, I have a couple of questions. One is, when you talk about abatement activities, what are you talking about?
We are. I don't know that I can give the exhaustive range. The goal was to put some guardrails. So, in other words, I was recently before the committee. We were talking about the Fund for Healthy Maine, the tobacco settlement. Yeah. As folks on this committee know, the tobacco settlement did not put any guardrails on how that money can be spent. Right. So when some states used it to pay for roads, pay for buildings, right. Maine did a much better job at saying, you know what, let's use this money for other purposes. So as part of, I think the best answer to the question should be Exhibit 1 in this document. What you're going to find are core strategies for how to deal with this. So for example, I'm just going to read the headings for some of these to give you the flavor. Naloxone or other FDA-approved drugs to reverse opioid overdoses, medication-assisted treatment, distribution, and other opioid-related treatment, focus on pregnant and postpartum women, expanding treatment for neonatal abstinence syndrome, treatment for incarcerated populations, prevention programs, expanding syringe service programs. These are examples of core strategies that are anticipated to be confronted by these overdose programs. The goal was to really, recognize there's a range of programming that's needed to confront the opioid crisis. It is not just going to be Medicaid-assisted treatment, right? It's not just going to be naloxone, but it was also to try to put a focus on that programming that has some demonstrated benefit to addressing the substance use disorder. There's also approved uses. There's a number of pages that address, treatment of opioid use disorder, support for people in treatment and recovery, connecting people who need help to the help they need, addressing the needs of criminal justice involved persons. So I'm sort of giving you what sounds like a really broad, it's meant to be broad in terms of how it addresses abatement. It is not intended to be so broad that these resources can be peeled off to pay for non-abatement related purposes. That's why the Recovery Council, frankly, is going to be so important for the 50% and why those voices were important.
Yeah.
Because, there is room to move within the parameters. And again, this is sort of consistent with conversations that have been going on for years with folks across the United States and in this state, to the extent that, certainly we've been paying attention to how things have been moving in this state. It was really meant to make sure we didn't tie the hands too much, not only for current programming, but recognizing that there will be programming that comes online. Addiction does manifest in different ways. So for example, if you look at the work that my office does to provide reporting on how fatal overdoses are impacting minors, you see that it's not just pills. You see it's not just heroin, fentanyl. You see it's not just methamphetamine. It manifests in different ways, and so that it was meant over the next 18 years, which is what we're talking about. It was intended to provide some flexibility. So that's a long answer. I hope it's responsive. And again, I mentioned that the details are included in the link that I'm including in exhibits. I think it's just Exhibit A, but that'll give you that idea.
Thank you. Just one other question. And the fact is, and I guess this is going to have to be a part of the decision-making, is we're talking about an 18-year limitation. So things stop in 18 years. Am I correct?
Yes.
Okay.
Well, this settlement does, right? Yeah.
Okay. So other settlements going on then that you're working on, does that then help fit those settlements into what's already in place? Or do we end up doing a whole nother thing?
So we've anticipated that this would be a structure to direct all of the receipts that come in for this purpose. So for example, Purdue, I don't know how much detail I may have provided on the Purdue litigation the last time we spoke, but there is settlement with Purdue that's sort of it's in the works. It may be closed in the very near future. It is expected that those resources will be directed consistent with this agreement because the same players are involved, right? I mean, different defendant, but it's still the state. I don't know if school districts are involved in Purdue, but we'll just put that asterisk there. Certainly political subdivisions are involved. Let me also add that this committee knows that this office had achieved a settlement with McKinsey, which was an advertising company that pumped up Purdue, oxycodone or OxyContin. So I have sat on that money, have not touched that money that's sitting in the Consumer Protection Fund right now, with the expectation that it would end up being directed in the same way, or at least to some of the same work that's identified by the Recovery Council, by the legislature in connection with the Recovery Council and with the executive branch. So that's another long answer, but I hope it provides useful information.
Thank you.
Representative Zager?
Thank you, Mr. Chair. And Attorney General Fry, I really appreciate it. What sort of coordination and communication do you envision among the folks governing these three different pots that you've outlined?
Well, so at least with respect to the Office of the Attorney General and the Recovery Council, I mean, I think for all intents and purposes, you might view it as really sort of 70% is going to be right. So the 20% to the to the Consumer Protection Fund, the 50% to the Recovery Council. I expect that there's going to be significant coordination, because we're going to be providing the legal advice to the council, right? But also because, as I think the whole committee is aware, the Attorney General pays attention to what's going on in the legislature, pays attention to sort of what's moving in different communities of relevance to this conversation. So I expect there'll be a fair amount of communication that covers 70%, right? With respect to the political subdivisions, I'm going to be an optimist that over the next 18 years in particular, there's going to be this opportunity not only for counties and municipalities to think about how the resources they're receiving may be used in a collaborative way, right? So, you know, you combine your dollars, you're able to do maybe more than what you could do on your own. Thinking about my stomping ground in Bangor, right? County of Penobscot, City of Bangor could combine their resources and think about how they could have some programming that might serve their mutual interests. It was anticipated that by having members on the Recovery Council from the political subdivisions, that would facilitate discussions between not only the political subdivisions and what they're doing with their 30%, but also how that same synergy might be achieved between, you know, hey, look, they got a program in Penobscot County. They need a little bit more money. They're going to work with the Recovery Council to get support and maybe, you know, fill the gap that they have. There is a potential there, and that's what is hoped. But I really can't. While I have confidence about this, about the OAG and the Recovery Council being collaborative in that way, you know, let's see how it works out with the political subdivisions and whether or not sort of the structure that was set up to provide the pathway for these conversations, if that works. Does that address your question?
It does. Thank you. I was just looking for, you know, just a little bit of your embellishment and thoughts on how that might work. That does help me understand. I have another question, but I'm gladly.
Go ahead, Representative Zager. Go ahead, Representative Zager.
Sort of separate, but with regard to indigent legal services, I mean, this committee has heard lots of testimony on how the opioid epidemic has affected child welfare cases, and obviously that has a lot of involvement with the courts. Can you please speak directly about how you see, you know, the need to provide funding to the judicial branch, as well as provide adequate legal representation to folks who are involved largely because of their involvement with substances like opioids?
Well, I'll try. So this covers, I guess this covers a couple of different things, and I'm going to put on my prior practice hat too, because I think, as this committee knows, prior to being elected to this position, I represented criminal defendants and parents in child protective cases. So I have some perspective from that as well, right? So I don't anticipate any of this resource being available for direct representation, right? So in terms of, paying for court-assigned counsel, paying for GALs, I don't anticipate this resource for that. But as your question highlighted, a number of these different contacts with child protection services, with the criminal justice system, may very well be related to the either substance use, the co-occurring of substance use, mental health. So, when I think about drug courts, when I think about programs that might be available to divert individuals to when they present, as a parent who's addressing a SUD or who has issues relating to their addiction, as a criminal defendant who, again, but for the fact that they're struggling with their addiction, I'm thinking that this is going to be an opportunity to augment some of these different diversionary programs to divert parents, divert criminal defendants too, so that when child protection caseworkers are saying, hey, look, we just need you to get these services so that we can get out of this. Or when, a defense attorney and a prosecutor work out that, look, if Aaron Fry, if you just get him into, this programming and can demonstrate that he's on the right path, we'll dismiss this case, right? That's where I see that these dollars may have the most benefit to the criminal justice system. Because frankly, to the extent that there are caseworkers, criminal defense attorneys, prosecutors, law enforcement, the way that they're going to be able to best do their job to make sure somebody's taken care of the way they need to be taken care of is to have some place to direct people to address what is the root cause of them being, in the vision of this, in the focus of the systems. So that's how I anticipate these funds being available. And of course, my hope, and again, this is sort of speaking from when I was in defense practice, there were times where I had somebody who would have benefited from some programming, but that programming just wasn't available, right? The parent or the criminal defendant. I do think this is an opportunity, not only for the political subdivisions, right? So to the extent that, look, Bangor and Penobscot, again, just thinking provincially here, to the extent that they can also work with their natural partners to expand the availability of programming to direct people to, there's going to be opportunities at different places to hopefully alleviate the need for the criminal justice system or the child protection system to be managing these issues.
I appreciate that and looking at those upstream social determinants. Really appreciate the answer. Helps me.
Senator Moore?
Thank you, Senator Claxton. I guess the question I also have would be this Recovery Council. In looking at LD 1722, it looks like the membership is a little bit different. Is the plans to amend 1722 to reflect what came out of the agreement?
So I guess let's stay tuned. It was anticipated that 1722 was a guide for how we might set something up that captured or that addressed a number of different concerns that 1722 was premised on, right? So ensuring that the dollars were going to be directed to a specific purpose, ensuring that there was going to be input from relevant stakeholders, frontline stakeholders, to ensure that these resources were spent appropriately. I know that 1722 is going to be up. I have envisioned that 1722 might be a vehicle to address if the legislature did want to add members to the Recovery Council, right? Looking through the agreement, there are some different pieces that we may need to be asking the legislature to weigh in on. So that's a long way of avoiding the direct answer, I suppose, Senator, which is 1722, it was not intended to supplant that necessarily. And it wasn't intended to do 1722 as written through an agreement with the political subdivisions in the school districts. this agreement was intended to reflect some of those concerns that generated 1722, but it wasn't meant to be an exact overlay of what was proposed. But I think it's still, I guess I haven't had a completely mature thinking about what recommendation I might make to this committee as to what to do with 1722. I think that might be coming up. There might be some plan for that to come up soon, and I'm going to plan to have a more direct, complete response when that comes around.
Representative Lemlin?
Thank you, Senator. I have a two-phase question. One, who makes the final determination at this point of where the money goes? And second, once that money is allotted to a resource, who, if anybody, makes sure that the money is used effectively? Is that monitored, or is it just left alone?
Let me start with that second question first. So it is anticipated that as part of how the Recovery Council in particular is going to be responsible for these funds, that transparency is going to include following what happens with the dollars and whether or not the what was proposed and what was ultimately accepted as an appropriate purpose, whether or not that that was followed through upon. Part of the work that my team is doing here in the office now is thinking about how to advise the Recovery Council on ensuring that that process is in place to have some accountability on those entities and how they're spending their resource, right? So I guess that's the first answer, and I would add that just as I answered to Representative Zager's question, I mean, I expect that process is going to be similarly used for the funds that flow through the Consumer Protection Fund. So, I mentioned that money comes in through the OAG, as do other consumer protection settlements, and money comes into the Recovery Council. That adds up to about 70%. I expect it to have that accountability system in place that's consistent with how the state, for example, does its contracts and does its support for programming. To your first question, in terms of who makes the decision, so political subdivisions, they're going to make their own, for the 30% that goes to them, they're going to make their own decisions about how to spend their money. I suspect that that's going to go through their appropriate governing bodies, but I can't say for sure what arrangements they're going to make internally for how that's going to go. For the Recovery Council, the decisions on how to spend are by a vote of that Recovery Council. And ideally it would be through consensus, but if there's some disagreement on how that on supporting a program, we built in that 60% of the membership would have to vote in favor of funding a program. So that, again, that makes sure that no one particular voice, state, political subdivisions, public members, nobody has the overriding the superior voice. And then with respect to the 20% that comes in through the Consumer Protection Fund, that's a fund that's been set up by the legislature. That fund is spent by the Office of the Attorney General, and so I'm overseen by the legislature in terms of that. So while I make the decision, I expect that folks will be paying attention to what I'm doing on the legislative side, which of course I'm going to be attentive to.
Does that address your questions, Representative Lemlin?
It does. I just, I guess I'm not 100% convinced that I would prefer it if your office would, I guess, monitor it more closely, and I'm not sure that you have the resources to do that.
Well, so I always appreciate the opportunity to talk about resourcing my office. So, so thank you for that. But here's so a couple things. One, and this actually is an opportunity. I do want to highlight that Assistant Attorney General Linda Conti and Assistant Attorney General Brendan O'Neill did a lot of work to get us to this point, to the extent that, I'm really excited about this opportunity. I want to publicly thank them for what it took to get us here. We do have experience through our Consumer Protection Division of monitoring how these consumer protection settlements are come in, are dispersed, line up with the terms of the settlements that we obtain. The settlement, at least with the political subdivisions and the school districts, it anticipates that it may get to a point where we need to be better resourced in order to ensure that we're providing the oversight that's necessary, provide the support that's necessary to make sure these dollars do the work that we need them to do. And so the Recovery Council can make that decision to use some of the resources coming in through the settlement to address that administrative need. So it wouldn't in the first instance, for example, come from the general fund, like not coming to the legislature saying, please give us general fund money to do this. Plus, we do have some other consumer protection resources that I'm willing to use as Attorney General to support, because a small amount from consumer protection resources to support ensuring that these dollars are spent appropriately. I do appreciate the concern about the resource. I do think we have present capacity to get this off the ground, and we'll be communicative with the Recovery Council and with, our partners in the legislature, our partners in the executive branch, about when we need a greater level of support. We've thought about that. We think we can get it started without a problem. But if we're successful, we may need some more, and we have some provisions to address that.
Thank you.
So I had a couple of questions, Attorney Fry. How about a standardized application process to quickly get into the weeds? How am I going to know whether to apply to you or to the Recovery Council if I have a project that I want to see funded or expanded?
So we have just put out our own call for Recovery Council members, right? So to the extent that I have appointments that I need to make, we are working on getting that group off the ground just as soon as we can, and as close in time to when we start seeing the money come in. And as part of their formation process, I'm expecting that I mentioned earlier, there's governance documents, bylaws that we're going to be expecting the Recovery Council to come up with. We envision that part of that will be, this is how you bring to our attention the programming, right? So there'll be the general application process. But by the way, to the extent that there are members from the legislature, the executive branch, political subdivisions, those who are leaders on the public side, I don't want to make it so formalistic that it only has to come through one portal. I think we want to make sure we have some different avenues for people to bring ideas to the table to go through. So I expect there'll be a formal process established through the Recovery Council, through the money that comes into the Attorney General's office. We have not landed yet on how it is that we would suggest that they bring programming to our attention. I can say only half jokingly that certainly haven't had a problem with getting ideas on how to spend money that's coming from other consumer protection cases that we've closed. But but in more seriousness, we have been thinking, although it's been basic thinking, about how we might ensure a proper structure for how we also receive proposals. But I want to add that it's not just going to be about directing the proposal to either the Recovery Council or to the Office of the Attorney General. I do expect that there should be collaboration through my office, HHS, the Appropriations Committee. There will be pieces of legislation and programs that are moving that, frankly, my office should also be paying attention to as an opportunity to to direct these abatement resources. So I think it's going to be a two-way street for at least 70% of the money. I can't speak to how political subdivisions are going to accept requests. And I can't, given some of the uncertainty that we've seen on how ARP or Recovery Act money has been spent, I can't say how the political subdivision is going to set that up. So in summary, I expect there'll be a public process for somebody to access set up by the Recovery Council. We're thinking about how it is that we're going to, in a formalistic way, accept and process requests on our side, right, to meet our obligations. Can't say on the political subdivision side.
So just a couple thoughts off the top of my head. This is a huge public health initiative. It's huge. And I can see the role for one of our higher education facilities getting involved with monitoring progress and giving updates. I can also see reports from the various divisions you've talked about being part of the standing agenda for the annual opioid summit. I think this just needs to be as high profile as possible to somewhat address Representative Lemelin's questions and make clear what the accountability is. This is a lot of money, and you're going to have a lot of people offering to help you get rid of it. And so we want to make sure that money gets used in the most appropriate, effective ways. So just a couple other thoughts.
Well, and I also want to use this as that opportunity to highlight that the certainly recognize that this council, my office, are not operating in a vacuum. And so to the extent that, with the accidental overdose review panel, with the work that Gordon Smith is doing, with the work that the legislature has, funded and directed, and some of the relationships that my office has already established in, for example, distributing naloxone directly from our office to law enforcement agencies, working with the University of Maine, Margaret J. Smith Center, right, to follow fatal overdoses. Fortunately, there's already some good partnerships that have been built that will help provide that elevation that, Senator, you just described is going to be so important to making sure that there is a collaborative, transparent process of taking advantage of this, potentially once in a lifetime opportunity to really confront the opioid crisis here in Maine.
Are you any closer to being able to approximate, now that everybody has reached a master settlement agreement, on this piece for these people or these entities, what the annual flow to the state might be?
Not yet, but let me take that as a question that the answer would be appreciated once we do have it. So I'll, if we could park that one, and I'll come back as soon as I do have that.
It's an open invitation. Thank you. Senator Moore.
Thank you, Senator Claxton. I actually took a look. I have a copy of this. I made a copy of the settlement. In the school administrative units portion of it, are all of the schools going to be eligible to apply for these grants, or is it only the ones that were involved in the litigation?
So we, and I hope that to the extent that the school district representations listening to this, I hope I reflected correctly. It was recognized that a single project for a single school district could eat up money pretty quickly, right? And it might benefit that school district, but not have maybe a greater statewide application. It was anticipated that for the resources that are specifically directed to the 0.03% that are specifically directed for the school district spend, that would be for projects that have statewide application. So to directly answer your question, it was not anticipated that only the litigating school districts are going to benefit from this spend. Instead, the objective would be, let's figure out if there's some standard behavioral programming or some standard intervention that can be applied across the state. That's what that's what the 0.03% would be directed to. That doesn't prevent, by the way, a singular school district coming in, whether or not they were represented by council with a proposal that, may be funded. But in terms of the specified spend, it was intended to be more of a general benefit and not only the litigating school districts.
Follow up?
Yes, follow-up question. Do we actually have a list of the school boards that did participate in the litigation?
There is a list of the school districts. I need to see if it's complete. It was in the original settlement documentation with Johnson & Johnson and the other the three distributors. So let me confirm that is the list, and I'll just send you that attachment. It was like attachment G or something like that in one of the settlement documents. So it had, I want to say it was somewhere around, it was a fair number of school districts. So I can get that turned around.
That'd be great, just so that we'd know.
Yeah.
Any idea when this money might begin to flow?
Ideally, we are still, and I may have suggested something along these lines when I was last before the committee. Ideally, sometime this spring, barring something that has not been anticipated by this office, the money could become available, anywhere between like April and July is sort of the time frame that we're contemplating. That does give us a little bit of time to get this recovery council, the members identified, get them thinking about how they're going to do their work, get them comfortable with each other. But it's not terribly far in the future for this resource coming in.
Okay, thank you for answering a lot of questions. Are there any others before we let you go and get on to your other duties? Thank you. We appreciate your time and the work that's gone to get us to this point.
Thank you very much. It's good to see everybody.
All righty. So I think we have a couple of, before we get to book reports, I think we have a couple of bills to consider for language. And I'll defer to Anna and Sam as to who goes in what order.
Should I go ahead, Anna?
Go ahead.
All right. So I had sent yesterday a kind of follow-up question for LD 1729. That's the insulin bill. I'm going to pull it up on the screen here. All right. So you should see the LD 1729. It's a kind of written over version. So two questions. So while I've got you, I will ask you about the change in the title. The revisor's office had suggested they suggest changes in titles to reflect better the amended version of the bill. So as you recall, anytime we reference insulin, we also are referencing insulin analogs to make sure that we are covering all forms of insulin. So they suggested just changing the title to read resolve to assess the feasibility of the production of insulin and insulin analogs in Maine. So that is, I think, fairly straightforward. So I'll pause there.
Anybody with thoughts about that? I lobbied for adding an S after insulin, so it read as insulins. But Sam didn't like that idea, so we offered the analog one.
So would insulin cover analogs as well?
Insulins would.
Insulins would. I am agnostic. I
am not, and I'm not lobbying for it, just reporting. Okay, so anybody who can't live with the change by adding and insulin analogs to the title?
So analogs would be any other type of insulin, is that what the term?
That's the broad net, yes.
Okay. I never had heard it referred to that, so okay.
Yeah.
So the
Okay.
other question, so the revisor's office is extremely good at double checking things. And one of the things that they caught that I did not catch was that the Maine Biomedical Research Board was one of those boards. So periodically, kind of inactive boards are repealed. So just last session, this was repealed. So it no longer exists. So we can't have a representative from the board appointed to the commission. So there's two options. You can add somebody else, a different person, or we can just strike it altogether and have 11 people on the commission instead of 12.
I vote for the 11 because that way you have an odd number that somebody can break the tie if there's a tie in the votes. But my only concern would be is if Senator Stewart had a specific reason why he wanted that board, someone from that board included. I don't know.
The other option might be to add a research facility, representative of a research facility, like Jack's, and then the numbers that are starting to pop up.
Or an alternative is an individual involved in biomedical research broadly.
Yeah, let's leave it broad like that.
I can do that. That's good. All right, so I will add an individual involved in biomedical research and replace that number. And that's all I've got.
Whoa, okay.
Thank you.
Thank you. And I think Anna had another one for us.
I do. Right, where is it? Is the question. Okay, hopefully you can see that. This is LD 1781. This is a department bill that was sponsored by Senator Carney. This is a unanimous report, and you did a couple of things here. I don't know how much backstory you need, so let me know if you need more, but the issue that generated the amendment was that this new eligibility from the federal government had a 5-year limit on it. But of course, we don't know whether that could be renewed. So the way around that, rather than putting a date in that you might have to come back and change, was to put in some language about being allowable by federal law. What I sent you last night actually is the official amendment. I just thought it might be easier for you to see it in the context. So the amendment doesn't look like this. It looks like what I sent you, but this is what the effect of it is to put in this language here. This is for all folks. So this is adding in the language that says beginning August 1st, 2022, and for as long as coverage is allowable by federal law. A little shout out to Erin for helping me figure that one out. And then down here, these are the non-citizens. And this was even more awkward because there's already language about the extent that coverage is allowable by federal law. But of course, this was referring to eligibility, not to the new law. This was around the sort of immigration status. So once again, Erin helped me with this one, and that's to include this language that says a non-citizen legally admitted to the United States for as long as and to the extent that coverage is allowable by federal law. So the for as long as is to match the piece above, and then the to extent that coverage is allowable by federal law, that's the immigration side. And then the last, I forgot to pull this up. So you'll just have to believe me unless you want me to find it for you. I also sent you last night the fiscal note, which is, as you expected, the department had said they picked the August 1st date so that it wouldn't require an appropriation. I can find it if you like, Senator Moore. I can see you looking at me like you really want me to find that for you. It is in your email though. That took a while to come for whatever reason, but it did what we expected, which is that the August 1st date was picked because you already appropriated money for this law last year, and that would mean that you wouldn't need more funding because the federal law, I believe, goes into effect in April, I think, and it will go into effect in Maine on August 1st, so that you didn't need to send it to the table. So that's not unexpected either, but you will have that in your email. But I wanted you to see the markup. So that's what I have for you for amendment wise. And that one's ready to go completely.
Any
So with-
comments? Everybody okay with those changes?
So with that, it's all up to you book reports now.
Oh, boy.
And I'm expecting 4.
How many conscripts, volunteers did you get?
Well, I believe you are one of them, Senator, but also I was expecting Representative Craven and Representative Griffin to do one each.
Well, if they don't mind, I'll just go first with my 2. One is a follow-up or fairly recent follow-up to the question that came up last session about backup electrical power to nursing facilities and other group homes. And we got a very thorough review of the requirements in a report from the department and Bill Monteo, who's the Director of Licensing and Certification. There are 1,128 licensed assisted housing facilities. And the rules are written based on how many people are in a given facility to a certain extent. And there are also federal requirements. So there's no backup requirement for electrical if there's 1 or 2 people in that facility, 1 or 2 residents. But each one has to have a contingency plan for loss of power, a contingency plan for short-term and long-term emergencies, and a backup plan if the power source fails completely and is going to be out for a while in terms of evacuation and rehousing. So there are fairly extensive requirements that have been put in place for the assisted living programs, the residential care facilities, and the PNMIs. But they do not include or do not stipulate that there has to be electrical power or a backup power source. And these are for facilities between 1 and somewhere over 6 people. So that's one thing. The other is that for multi-level facilities where there's assisted housing and a nursing facility, those have to meet standards that provide emergency power throughout the system. So if you're Clover Living Center in Auburn has an assisted living side, an independent living side, and a nursing home side. If you have a nursing home side, then you've got to have backup power to those areas that are either the nursing facility or the assisted housing facilities and the assisted housing facilities. Those are CMS requirements and they're part of the licensing process. So looking back at the bill, I'm not sure what that would have accomplished for us that isn't already in place when we know more about the details of the rules and regs. Any questions about that? Sorry, I couldn't make it as interesting as some of the predecessor book reports. The other thing I found, other book report I found very interesting because I'd never heard of this before, but we have a advisory committee on family development accounts. And it's a provision that was set up in 2000, I think, yes, that allows people with very limited assets, those with and who qualify for TANF at the 200% or below, to begin to acquire slowly and legally acquire assets towards one of a number of different things. So there's a matching program in place, but if you wanted to save up for a first home purchase or an automobile purchase or for tuition, you can save up to $4,000 and have that matched 2 to 1. So you can end up with savings up to close to $8,000 to allow you to do the car or the house or things like that. So it feels like a significant bump from out of folks who are living at or close to poverty level. And so you open one of these things called an FDA, which is the Family Development Account, and you designate it for a certain thing that you're saving for, and then you begin to set aside. The average set aside over the 10 years the program has been in place, or the last prior 10 years, was a little over $100 a month. So it's not big money, but that's $1,200 a year. You do it for a number of years in a row, and then you get somewhere a match between 1 to 2 and 1 to 4. You really can't, and depending upon which of those various things you're working for, it really puts people in a much better position to be successful. There were, as of December 2020, this is an old report, there were 133 people saving towards these major asset purchases as they're described. And for most of them, it was a home, some it was a car, some was starting up a small business, and some it was education. As part of this, in addition to saving money, you also get financial education classes. So there are certain financial institutions, and there's a list of about 20 banks that are participant in this. And they and some other entities provide asset-specific training before you pull the trigger on acquiring the asset, as well as financial training early on to make saving a habit and get you more familiar with the ins and outs of how to accomplish what you want to. So if you're on TANF or you qualify for earned income tax credit, you can open one of these accounts. And the matching varies a little bit, but in the past 10 years, there were 600 accounts were completed. Over 600 people maxed out what they could save. 180 of those went to home ownership. 112 went to education. 130 went to vehicles. And some went to emergency savings. You're allowed to do that. So that's 600 accounts that matured. So that's not bad over 10 years. And 257 account owners committed, but then withdrew because they weren't setting aside money on a regular basis and weren't allowed to continue. So not bad. So 177 homes, 37 businesses, 28 graduations, and 6 vehicles. That was the 10-year report ending in 2000, or since 2000. So for that 20 years. So there are advisory councils, there are resources in the community. As I said, there's a list of about 20 banks that support this effort, and a range of community development organizations who are resources for the individuals and advisors for the process. So something I didn't know we had one of those, but it looks to have been successful at a certain level. Representative Zager.
Senator, who puts up the matching funds? Is that the banks or the
Some of this is federal, some of this is private, and some of this is state money. And in the last year, they've allowed much more flexible access to those monies to help people get through the pandemic. So this is a combination of sources, and they regularly submit donations. Some of the banks see it as part of their community support, community volunteer donations money. So there's an advisory committee and there's a resource of community development organizations. Those two are the steering entities. Any other questions? I got my 2. Next.
I'll go next.
Very good.
Yes and no, you did an excellent job. It was very interesting. just so you know.
Well, I can't make it as animated and as entertaining as some, but
I know. And mine's probably, I had to write mine out, so, but mine's on the Drinking Water State Revolving Fund. And it's the report is from 2020. And the Drinking Water State Revolving Fund provides essential funding for drinking water infrastructure improvements in Maine. In 2020, the Maine CDC Drinking Water Program dedicated $22.6 million in loans and grants to construction projects at 14 public water systems serving 32 communities in Maine. The 1996 amendments to the Safe Drinking Water Act included allocations for Drinking Water State Revolving Fund, which is DWSRF. This is a state operation program providing loans and other financial assistance for drinking improvement projects. Such projects include improving or replacing water system pipes, treatment plants, storage tanks, and sources of water to ensure safe drinking water and provide essential public health protection. A portion of the DWSRF is used to fund non-construction projects that help to improve and protect drinking water quality in Maine. These include wellhead protection grants, soft source water protection grants, capacity development grants, very small system compliance loans, grants, and land acquisition loans. These programs are to provide source water protection, technical assistance, system capacity development, and land acquisition. HHS and the Maine Municipal Bond Bank administer the dwarfs together. Since 1997, the Maine Drinking Water Revolving Fund has provided over $325 million to public water systems through low interest loans and grants. In 2020, the COVID-19 pandemic brought many new challenges for public drinking water systems in carrying out daily tasks associated with providing safe drinking water. All were carried out on time and within the budget despite the challenges. In 2021, the DWSRF federal allocations combined with state matching funds and repayment funds will allow $20 million for new drinking water infrastructure projects. Even though this is an impressive amount, it does not adequately fund the needs of updating and replacing aging drinking water infrastructure in Maine. There were 47 applications representing 72.4 million drinking water improvements submitted in the 2020 funding cycle. There is a funding gap of 51.4 million. Many water systems are only replacing the critical needs, so customer rates are not increased. Leaders will have to make difficult decisions. The maintenance and improvement of Maine's infrastructure is vital to our economy, our health, safety, security, and to the environment.
very good. Are there questions of Representative Griffin in that report? What was the date on that report, Representative Griffin?
It's 2020.
So that may look a little different with some of the ARPA money and infrastructure money. So let's hope. Let's hope. And who else was going to, Representative Craven was going to give a look report.
Yes, thank you, Mr. Chair. And my report is on the Maine CDC Birth Defects Program, and it's often referred to as the BDP program. So the program began developing a birth defects surveillance system in 1999 with funding from the U.S. Centers for Disease Control and Prevention. And the Maine CDC birth defects program was established within the Maine CDC to identify newborns with birth defects, to make sure that newborns with birth defects receive appropriate specialty services and to monitor birth defects. The Maine CDC birth defects program is aligned with the most current listing of reportable birth defects to reflect the birth defect surveillance guidance developed by the CDC National Birth Defects Program. The Maine CDC Birth Defects Program gathers data about infants born each year with certain birth defects diagnosed within the first year of life. The statute requires that the Maine Birth Defects Program, number one, collect, analyze, and distribute information to identify the birth defects with regard to the following causes: risk factors and strategies for prevention, and the provision for services. And second, establish a system for data collection that identifies prevalence and incidence rates by region and population growth, and identify the morbidity and the mortality rates resulting from birth defects. And third, conduct investigations to determine the nature and extent of the disease or known or suspected causes of the birth defects. Collaboration with the Maine CDC Environmental Public Health Tracking Unit shows 12 of the 45 birth defects on the Environmental Health Tracking Portal. The baby identified with the confirmed birth defect is referred to the Department of Education, Part C, the CDC agency, for follow-up for early intervention services. Another birth defect is the cleft lip or palate. The Maine Birth Defects Program currently supports and collaborates with cleft lip and palate clinics. The Maine Health, Maine Centers for Northern Light, and Maine Health and Northern Light are providers. All families with prenatal or postnatal diagnoses are offered a visit from a public health nurse to provide support, answer questions, and connect families with the cleft lip and palate clinics. Altogether, there are 57 birth defects that are listed. I couldn't pronounce them. They were all scientific names here. But the Maine CDC receives medical discharge data electronically from all birthing hospitals. Currently, the Maine CDC Birth Defect Program sends all hospitals a monthly electronic reminder to submit the data. Let's see, infants, potential cases are identified through weekly downloads of both the electronic birth and infant death certificates and medical records discharge data. Once a potential case is identified, extraction is performed using a comprehensive electronic abstraction method. Information collected includes the nature and details of the birth defect, demographics, mother's health history, parental information, and cytogenic and laboratory data, family history, and when available, the father's history. Personnel and funding for the Maine CDC Birth Defects Program is one full-time employee and a part-time epidemiologist. The Maine CDC currently contracts with partners to provide data registry abstraction services, as well as to facilitate the cleft lip and palate clinical services. Goals and achievements: families may attend clinics until the child is 22 years of age, regardless of income. Families attending clinics have access to multidisciplinary teams, including a geneticist, genetic counselor, plastic surgeon, oral surgeon, an orthodontist, a pediatric dentist, ear, nose, and throat specialist, nurse practitioner, speech pathologist, social worker, and clinical coordinator. This team of specialists work cooperatively with families to develop the best treatment plan for each child's condition. Children with a cleft lip and or palate can find comprehensive care at Maine's cleft lip and palate clinic locations. This year, each site began working towards becoming a team approach. the American Cleft Palate Craniofacial Association. Clinic sites also provide a full range of education and consultation services upon request, in addition to monthly clinical services. Additionally, clinical sites are working to provide family and community educational opportunities on an annual basis. The 2020-23 to 23 clinical sessions were offered serving over 100 families, including telehealth clinics to support families during the corona pandemic. That's it.
Very good. Are there any questions? I'm not seeing any. So I'll turn to Anna and see if there's anything else we needed to do this morning.
No, but I wanted to, at the risk of sounding like the professor trying to make the students do their homework, I was wondering if we will probably have some time next Tuesday afternoon and possibly Wednesday afternoon. So I'm not going to press gang anybody because I don't have that power, but I can see Ann Perry putting her hand up. Thank you. And Sam, do you have any representatives, Agar? And then the next thing is I do have a few that I could assign because nobody is answering my email. So I'm going to try and do it in person. So I have the prescription monitoring program going begging. Would somebody like that one? Whoa,
I can
look
do
at
that
everybody.
one. I'll do that
Okay.
one. I think I did
All
that one
right.
last time too. So
I think you did. I think that's
Yeah.
right. And then we also have the letter from Chief Justice Stanfill about the Independent Examiners Board. This is the medical examiners for involuntary commitment. This is just a letter. I haven't had anybody sign up for that one yet. Would somebody like to do that? Well, Senator, you're the chair. Why don't you pick of all the hands up? Who you
I
would like to
saw
go to?
Representative Leveland's hand up first.
All
so-
right. And then Substance Use Disorder Services Commission. Okay.
Thank you,
And-
Representative Madigan.
The Maine Developmental Disabilities Council Annual Report.
Is your hand up for that too, Representative Madigan?
I just want to say my internet connection has been unstable all morning, so I'm not catching everything that Anna.
That's
Anna
all right.
said. So
You put your hand up once, so I'll take that.
okay.
You
So
guys
who
are
would
signed
I-
up for
if you
6
could
book
send-
reports.
You don't want to do that. I'm only one.
No, I don't blame you. So who would like the DD Council report? Somebody want the Developmental Disabilities Council report?
I'll take
Annual
the
report?
DD Council.
Okay, and then, and I hate to ask you these questions on mic to put the chairs on the spot, but I'm wondering if you would like the McWAP report in person rather than assigning it, since we have a lot of child welfare bills coming up.
That'd be
Yes.
great.
Yes.
And then perhaps also not exactly the same, but similar, because they do home visiting, but the Maine Children's Trust.
Yes.
Okay, so we'll see if we can schedule those, and maybe we'll even be able to schedule them next week or on the 7th. Okay, and I think that's it.
Very good.
But I still see Representative Madigan's hand up, so I don't know if she has a question.
I was going to ask.
Oh, okay.
It's still up. Yeah. It goes down reluctantly. Yeah, Senator Moore.
I was just going to make a comment that I've kind of worked through this myself. I know Anna and you had assistance with it, but we have the links to those reports that are on your Excel spreadsheet. So it would be helpful when whoever's giving the report would tell us what number it is on that chart, and then that way we can actually click on it and follow along with the report itself. It made it a lot easier for me today, but I was searching by person instead of by the name of the report. And then once I found it, then I was able to look at it. It would just be helpful, I think, for future book reports.
Okay. Oh, and one last one. I'm thinking that because you had a syringe board bill the other day, and you, I guess, talked about the numbers, that you could probably, if you would like, skip the syringe services annual report, since you've already visited that issue. So that was my last one. I was waiting for Sam to respond. So I'm good to go. Thank you.
Very good. Any other?
Tuesday afternoon, everyone. Sorry, Tuesday afternoon.
Okay, we'll start right at 1 o'clock. We'll adjourn until then.
Representative Perry, are you intending to be on video?
Good afternoon, everyone. Hope you enjoy your longer than average lunch break and the sunshine. If the people well, let's do this the way we normally would, and I'll do the regular introduction for those folks who are watching us. This is the afternoon session of the Joint Standing Committee on Health and Human Services. It's a work session where we'll consider a number of bills and try and figure out what we would like to do with them from the committee point of view. You can watch the proceedings on the YouTube channel if you're not on the attendee list. And everything that we do is recorded there and available for later viewing if you would like. We haven't had too many technical glitches so far today, but I know there are some in our future. So please bear with us while we sort those out. We've been successful getting things to work right with a little bit of time. So since this is a work session, we won't be taking testimony. The committee is free to ask of anybody who might be a resource, any clarifying questions they have. And I see a number of people who have joined us who might fall into that category. So I'd welcome them. I remind people that when you come into the room, you have to go through the wormhole. And don't give up. We haven't lost anybody yet. So it works. It just takes some time. So with that, let's quickly introduce ourselves, starting with Representative Zager.
Thank you, Mr. Chair. Good afternoon, everyone. Sam Zager, District 41, Portland.
Representative Lemlin.
Thank you. Good afternoon, everyone. My name is Michael Lemlin. I represent House District 88, Chelsea, Jefferson, Whitefield, and half of Noblesboro.
Representative Perry.
Good afternoon. I'm Ann Perry. I represent House District 140, which includes the communities of Indian Township, Baileyville, Barron, Calais, Charlotte, Robbinston, Perry, Pembroke, and Pleasant Point.
Representative Stover.
Good afternoon. My name is Holly Stover. I represent House District 89, including the towns of Boothbay, Boothbay Harbor, South Port Edgecombe, West Port Island, and part of South Bristol.
Thank you. Representative Griffin.
Good afternoon. My name is Abigail Griffin. I represent House District 102, which is Glumber, Levitt, and Cadestic.
Representative Craven.
Thank you, Mr. Chair. Good afternoon. I'm Margaret Craven, and I represent House District 59, which is part of Lewiston.
And Representative Madigan.
Thank you, Mr. Chair. I'm Colleen Madigan. I represent House District 110, which is part of Waterville and part of Oakland.
Representative Perry has joined us. When she's unmuted, we want to have you introduce yourself. You want to try the space bar trick? Just pushing down on the space bar.
I believe she already introduced herself, Senator Clarkson.
Okay, I'm just going through the list here. Thank you. That's why she's ignoring me. That won't be the first time. So thank you for that. Representative Javner.
Thank you, Mr. Chair. I'm Representative Kathy Javner, and I represent House District 141, which is located in beautiful Penobscot and Washington County. And I am being serenaded by such a cacophony of songbirds. I wish you all could enjoy it with me.
Senator Moore.
Oh, I love that. That's excellent. Good afternoon. I'm Marianne Moore, and I represent Senate District 6, which is all of Washington County, as well as Goldsboro, Winter Harbor, and Sullivan in Hancock County as well.
Representative Meyer.
Thank you, Senator. Good afternoon. I'm Representative Michelle Meyer, serving Southern Maine's House District 2, which is all of Elliott, where I live, and parts of Kittery and South Berwick.
And I'm Ned Claxton, honored to represent Senate District 20, which consists of Auburn, Minot, Mechanic Falls, Poland, and New Gloucester. When I reference some of the technical issues, some of those in IT would be considered operator error. So now we'll introduce our staff who lets us get through our workload and organizes things. So I would have Anna, introduce yourself. I couldn't find you.
That's all right. Hi, I'm Anna Broom. I'm one of the legislative analysts for this committee, and I work in the Nonpartisan Office of Policy and Legal Analysis.
And Karen is our clerk.
Hi, I'm Karen Thomas, the clerk for the Health and Human Services Committee, and please email me at hhs@legislature.maine.gov should you need anything. Thank you, Senator.
Okay. So we have a number of folks who are resources in the attendee room if we want them. I'll defer to Anna at this point to introduce the first three bills we'll be considering related to the Ombudsman's office.
Do you have a particular preference for order? Because I've had to do them all separately.
Oh, you can do them whatever order you want. I mean,
all right.
You did all the, if we start with the three from the related to the Ombudsman, I'd like to get those as a group.
Yeah. Right. Well, they're the ones that are scheduled for one, but I just didn't know if you had a preference within that. Okay. So I will start with whatever shows up here. Is this 1960? Are you looking at 1960?
Yeah. Yes.
Okay. For some reason, I can't see any of you, however. All right. Well, we'll worry about that in a minute. But you'll have to shout at me because I can't see anything. Okay, so LD 1960, this is the Governor's Bill, an act to make changes to the laws governing the Child Welfare Services Ombudsman Program. And it makes a number of changes to the Ombudsman Program. It provides that the director of the program must serve full-time and expands the director's required experience to include child welfare. It provides that the staffing for the Ombudsman Program is at the discretion of the nonprofit organization under contract to provide those services. It provides that the contract to provide those services is for a period of 5 years, except that the contract may be terminated consistent with the terms of the contract. It provides the contract to provide ombudsman services must include funds for the nonprofit organization to provide health insurance to its employees. And it provides that the Ombudsman Program must provide information about its services through a publicly accessible website and makes a technical correction about plural language. It clarifies that the Ombudsman may provide opinions and recommendations on current or proposed state programs, rules, policies, and laws. And it clarifies that the Ombudsman Program may provide input on the state's child welfare system to the department and the HHS committee. It clarifies that the Ombudsman Program provides services to persons and families involved in the state's child welfare system. It requires the department to notify the Ombudsman Program of any statewide policy changes affecting the state's child welfare system before those changes take effect. And it requires the department to notify the Ombudsman Program of certain child fatalities. You heard from the Governor's office that there is funding in the budget that is in addition to, there was an addition earlier this month to the contract amendment. There was a contract amendment that added $52,284 to its contract, and this would, combined with what's in the budget, would add $192,284 into the baseline, and you can see what it used to be. It provides for additional staff and office space as the Child Welfare Ombudsman chooses, as well as the health insurance requirement. It strengthens the independence with a longer contract and codifying the practices of the Child Welfare Ombudsman, providing recommendations to the department and the committee on programs, laws, and policies, and being informed of upcoming changes to the system and child death. And then you heard from the Child Welfare Ombudsman, who I know is also here. She said she's grateful for the funding proposal and that all the proposals in the three bills strengthen the independence and productivity of the office. And she gave you data on the number of calls that have increased from 282 in 2011 to 708 last year. And they added one staff person in office space in 2019. You also heard from the Maine Children's Alliance about bolstering the child welfare capacity and authority, and that they'd also like more authority of other panels with oversight over the child welfare system. So the additional information, I don't know if it will let me do this. Can you see that I have changed screens there or not?
Yes, you have.
Okay, so this is just the piece in the budget just to show you the 140,000 that is in the funding part, but also part BB in the budget is almost exactly the same language. There's actually an error in here that is not in the bill, but otherwise it's the same. The error is that I believe this health insurance is in two places in this section. So that I just wanted to show you that language was also in the on the Bureau of the Budget website. And we haven't yet received anything from OFPR. There may well still be a fiscal note because of the health insurance requirement, but I don't know the answer to that yet.
Thank you. So what's the will of the committee? Would you like to hear about the other two bills related to the Ombudsman's office now, or do you just want to work on this one? I didn't hear you, Senator Moore, but
I'm sorry, I propose that we listen to the analysis and all the other two as well.
Okay.
Especially because some of it is duplicated in one of the other bills. So I think that would work good. And then that way we could begin working on all three of them together.
thank you for that. I see a number of nodding heads and general assent. So we'll go to that and go back to Anna for whatever the next of the other two that you'd like to introduce. You're muted, Anna, if you're talking.
I see that, sorry. It just told me I was unmuted at the same time. I can't see any of you, but it would tell me that I'm unmuted. I guess that's useful. Okay, LD 1812, take two. An act to strengthen the Child Welfare Services Ombudsman Program by providing for increased staffing. This bill provides ongoing funding of $250,000 in general fund in each year for 2 associate ombudsman positions and 1 administrative assistant position in the Child Welfare Ombudsman Program in the executive department. You heard from the sponsor that there has recently been a more cooperative approach to the Child Welfare Ombudsman Program from DHHS, but that the office needs more resources as the only independent and reliable connection to the public and the legislature. And he also said he supported LD 1755. Just a reminder once again about the supplemental budget proposal, and then just skipping down to the fiscal impact before I go back to the drafting. The OFPR preliminary fiscal impact statement is general fund appropriations to the Child Welfare Ombudsman within the executive department of $250,000 in fiscal years 22 and 23, and then outgoing, but this bill is not drafted as an emergency, so it would make sense to remove the funding from the first year of fiscal year 22, since that will end in June, that there wouldn't be time to spend the funding in that first year. So that's the first one. And would you like me to move on to 1755?
If you would, yes.
All right, 1755. Okay. Okay, 1755. So this is a much more complicated bill with a whole number of issues associated with it. So I apologize, it's going to take me a little bit of time here. So this is an act to enhance the Child Welfare Ombudsman Program. And I decided the easiest way to do the summary of this bill was not to use the summary as it's printed, but to go through each section of the bill. There's no perfect way to do it, but it might be easier if you're trying to follow along. So section 1 of the bill includes the Child Welfare Ombudsman as a member of the Child Death and Serious Injury Review Panel. It requires the Department of Health and Human Services beginning January 1st, 2023, and every 2 years after to submit a report to the Joint Standing Committee having to this committee on that panel's recommendations. And section 2 of the bill just clarifies that the commissioner discloses the conclusions of the panel on request and the committee pursuant to that amended law. So section 2 relates to section 1 a little bit. Section 3 establishes that the Child Welfare Ombudsman as an independent program rather than independent within the executive. It provides oversight of child welfare practices and policies, requires 3 ombudsmen and a full-time administrative assistant, and requires office space and budgeted funds. Section 4 establishes the Child Welfare Ombudsman as a non-profit to provide investigative oversight and advocacy services. It requires the ombudsman to be appointed by the governor, subject to the Health and Human Services Committee review for a 4-year term of office. It requires state health insurance and retirement benefits to be provided, but it also states that the folks working for the Child Welfare Ombudsman office would not be state employees. It requires the Ombudsman to submit the Ombudsman budget's recommendations using a format prescribed by the state budget officer as part of the Unified Current Services Budget legislation. Section 5 authorizes the Child Welfare Ombudsman to provide system-wide comment to the department and the committee. It also requires the office to provide oversight of child welfare services as the Ombudsman considers important. It requires the department to inform the child welfare officer, ombudsman, of any statewide policy or practice changes in child welfare before they take effect. And it allows the child welfare ombudsman to have input into training initiatives for personnel in and outside DHHS, including mandated reporter training. Section 6 allows the child welfare ombudsman to disclose confidential information, records, or case-specific reports to the HHS committee, a joint select committee, or an oversight committee of the legislature meeting in executive session. And Section 7 adds the government oversight committee to the committees of oversight over the child welfare ombudsman. In other words, both committees, so HHS and GOC, would be authorized to submit legislation. So you heard during the public hearing that the sponsor is looking to increase the independence of the Child Welfare Ombudsman program. You heard from the chair of the Child Death and Serious Injury Review Panel that he would welcome the inclusion of the Child Welfare Ombudsman on that panel and support the requirement of the biennial reports to be submitted to the committee. So that's section 1 of the bill. He also expressed some concerns about confidential information being shared with the HHS committee in executive session. And if the Child Welfare Ombudsman was on the panel, the Ombudsman would have access to case-specific records, and that there could create some sort of conflict with different standards for confidential records. In other words, they're confidential in one place and not in another. And then the Office of the Attorney General also commented on this part related to the confidentiality, the expansion of the office to relevant oversight of child welfare services as the Ombudsman considers important to the rights and safety of children and families is not consistent with the original purpose of Child Welfare Ombudsman, and it would become another oversight body without defining the nature of the oversight, and that there's insufficient resources for system-wide oversight. And then I got ahead of myself a little bit there. The OAG and the department have concerns about disclosures to the HHS committee in executive session. Children would have their confidential information disseminated to legislators, and that could also hamper the department's ability to gather information, and then information shared may not be reflective of the department's broader activities. So there are a number of drafting issues here. So the legal status of the Child Welfare Ombudsman within the state government isn't clear. It looks like a state agency established in statute, appointed by the governor and confirmed by the legislature, state office, oversight over child welfare services and participating in departmental policy development, but it's also identified in other parts of the bill as an independent nonprofit organization and not considered state employees. The Ombudsman and staff are considered state employees with access to insurance, health insurance and retirement. We're not actually sure if that's possible for retirement, and yet they're not considered state employees. And then if you want to move forward, you'd need to clarify the oversight or policy-making role with respect to any programs for which the department currently has statutory responsibility. Just a reminder about the confidentiality issue. And then I don't know whether this fits with the OPEGA statute and the GOC oversight. It's a little bit up to you, but what is definitely not clear is what the oversight between the two committees means. Like, you would need to add some specificity of what that oversight means and who does what. And then some additional information about executive session. So the executive session law is in Title I, Section 405, which is the Freedom of Access law. It would appear that these kinds of records are already covered, so that wouldn't need to be added in that sense. And you can see somewhere in here, I believe it's subsection 3. If you were interested in how this would work, an executive session may be called by a public recorded vote of 3/5 of the members present and voting. So that's how a committee would go into executive session. And then there is also a joint rule further down here on what happens to the records that if a committee goes into executive session. And my understanding is that this section means that you wouldn't keep the records, that the records would go back to the child welfare ombudsman who is sharing them with you. So I'm going to unshare my screen because I can't figure out how to see you all again. And I'm going to fiddle around with that while you think.
Excuse me. Thank you, Anna. So before we proceed to talk about the bills, I see that Senator Diamond is there. So I think he probably heard the analysis from Anna, and I just want to make sure he has a chance to give us any feedback about the analysis of 1812.
Thank you, Mr. Chairman. I did hear it, and I thought it was accurate, right on, and it was it's pretty basic and simplified bill. So as far as 1812 goes, I think it's is exactly as Anna had presented it to you.
Very good, thank you. All right, so we have other folks available to help us answer questions if they come up. So Representative Javner.
Thank you, Senator Claxton. I'm sorry, did I jump the gun on questions?
Not at all.
Okay, I'm so sorry. So I have a question for Senator Diamond. If you could possibly just share with us them now your feelings of having seen LD 1960 as well from the governor's administration. What is it you are still looking for from 1812? Could you just let us know how you're feeling about that?
Thank you very much, Representative Javner. No, I think the governor's bill covers that. What I think the governor's bill may be, you may want to look at for your own decision making on the independent piece. I'm still concerned that it has a contract situation, but I didn't call for that in 1812 either. So that's more with Senator Curry's bill. But no, I think what the governor has done in terms of, I was just looking for more staff and more support for the ombudsman. And I think 1812 did that, but obviously I think the governor's bill does it as well.
Thank you.
And obviously these bills were submitted at different times, different sequence. Right. So yeah. Are there other questions of these three bills that we're considering currently? Yes, Representative Javner.
I'm sorry, could Ms. Alberry be brought in if she's not yet?
Sure, we can do that.
I have a couple questions for her on 1755.
She's in the wormhole. Welcome, Ms. Albery. Thank you for being here.
May I go ahead with my question? I'm so sorry.
Let's have Ms. Albery introduce herself first. We can see you. It looks like you're unmuted, but I haven't heard anything yet. Can you hear us?
Now I have you now.
There we go. Thank you for being
Great.
here.
Thank you.
Care to introduce yourself?
My name is Christine Alberry, and I'm the Child Welfare Ombudsman for Maine.
Thank you again for being here. Representative Javner had a question or two.
Thank you, Senator Claxton. Ms. Alberry, were you able to hear the analysis for 1755?
Yes, I was.
Anna? Okay, so I have one question about the first section that Anna talked about, the member becoming a member of the Child Death and Serious Injury Review Panel. Would you just let us know how you feel about that and what the positives or negatives would be from joining that panel?
Thank you. Yes, so I'm strongly in support of the Ombudsman having a representative on the Serious Injury and Death Review Panel. I think one of the things that would be a real benefit for us and hopefully for the Serious Injury and Death Review Panel as well is, as you know, their mandate is only to review cases involving child serious injury and death, whereas ours is a complaint-driven process, and we can review cases involving all different types of child abuse and neglect and child welfare involvement. as a result of this, the panel has a great deal of medical expertise and other people that we don't. I mean, I actually, many of the doctors on the panel have been really great about answering some of my questions, but we would have access to that. They would have access to more of our, our opinions about, abuse and neglect that aren't necessarily serious injury and death, related. And then also we would have a better sense of what is really, a lot of the questions that everyone has been asking since the highly publicized deaths in this spring and summer occurred is, what does this mean? What do all these statistics mean in terms of there are more deaths this year? It would give us access to that information, and we could be involved in, again, I'm not exactly sure because I haven't been to any of the panel meetings, but we could be involved in having, gaining more knowledge about exactly what all of this means in terms of the broader child welfare picture.
Thank you very much. I have one more.
Please.
And so in section 5, it was quite lengthy. So can you just tell us what part of section 5 isn't already happening?
Hang on.
I don't know if you can see that, or if we could
Do you
bring that
wanna-
back up even.
Do you want to put section 5 back up, Anna, if you could? Oh,
Section. Oh, the part with services, is that what you're asking about, Representative Javner?
I believe so. I apologize.
Okay.
I actually will need to see it again myself.
That's okay. So I think that's what you're asking about. So, so this part doesn't change a lot. Let me just make sure I'm looking at the right thing. Yep. This part doesn't, all of this is essentially already happening. Let me just take a look here. I think it clarifies that the ombudsman provides system-wide comment to the department and the Joint Standing Committee of the legislature. I think that already has been happening, but I think it clarifies that that is in fact one of our duties to provide. And then it also, again, it doesn't change a lot. And I'm just trying to see here. Oh, the biggest change in this section is the part sort of towards the end of the section. The department or designee of the department shall inform the ombudsman of any statewide policy or practice changes in child welfare before those changes take effect, and the ombudsman must be allowed to participate in any department training, studies, or policy development activities at the ombudsman request. That is, and I'm sorry, we're still talking about 1755, right? Yeah, okay. That would be a change, but I think part of that is already in the governor's bill as well. And then the ombudsman must have input into training initiatives. That part is also a change as well.
Thank you very much.
any other questions? Does that answer them, Representative Javner?
Yes, thank you. That's very helpful.
Any other questions of Anna or our various resources? Yeah, Senator Moore.
Thank you, Senator Claxton. I guess the one question, again, I'm back on to the 1755. And Christine, I know right now the way that the organization is set up, you report directly to the governor or the executive. And in here, it was talking about it being a separate independent, which was a section 3, I think, as an independent program. What are your thoughts about that and how the current system is working?
Sure. So right now, so essentially because we're a nonprofit, and I don't think 1755 would change that, really I report in terms of program and, job performance and all of those types of things to my board of directors. However, we also do a report to the Department of Administrative and Financial Services, who actually administers the contract. So that's, and that has been, as I think I said the other day, we have not actually had any issues in terms of worrying that the contract was going to be terminated early. It has been year to year for a few years. It's the usual RFP contract process. So, and I don't know if you need more clarification. It's a little confusing, I know.
So if we changed it and went with the governor's bill, and I think it also addressed that in 1755, changing it from a 1-year contract to a 5-year contract, that would make it a lot smoother, don't you think, as far as the administration part of it?
Yes, and it certainly, I mean, again, I think this is a theoretical worry that the contract would be terminated. It certainly would make things a lot easier for us for planning purposes. But I think, again, that was the 1755 concern, is just that contract could be terminated. But I think the appointment also, I think each system sort of has its pros and cons. But yes, I mean, it would certainly make things a lot more administratively easy for us.
Follow-up questions, Senator Moore? Oh, okay. So is it a fair statement, Christine, that in the conversations with the governor's office, you considered various structures for housing the ombudsman, and this is where you settled? Is that a fair statement?
Yes, I mean, we actually, we definitely discussed, the other, because the idea of having an appointed position, I think, is something that was, brought up in 2019 in similar legislation. And this certainly is, I think the contract proposal is a great way to go about it instead.
Okay. Great, thank you. Are there other questions? Thank you for being here. I'm not seeing any. So does anybody want to make a motion? Representative Meyer.
Thank you, Mr. Chair. So in light of the fact that Senator Diamond's bill is essentially an appropriation, and the funding is in the budget, I would move ought not to pass on LD 1812.
And I would second that motion.
And there's a second of that from Senator Moore. It was made by Representative Meyer. Any further discussion of that? I'm not seeing any. So at this point, Representative Perry has a question. Hand up.
Yeah, I'm a little slow here. Actually, the question I do have is there is a piece in that bill that, I think it's that one, that has the ombudsman joining the child death. That's not the one.
That's not in 1812.
I just didn't want that to get lost.
Okay. So there's a motion on the floor, ought not to pass on LD 1812. I'm not seeing any other points or hands up. So I will turn it over to Karen to run the vote on 1812. And the motion is ought not to pass.
Right, Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
Yes.
Representative Lemlin, yes. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci. Senator Baldacci is absent. Representative Perry.
Yes.
Representative Perry, yes. Representative Jabner.
Yes.
Representative Jabner, yes. Representative Madigan.
Yes.
Representative Madigan, yes. Representative Craven.
Yes.
Representative Craven, yes. Representative Connor. Representative Connor is absent. Representative Griffin.
Yes.
Representative Griffin, yes. Senator Moore.
Yes.
Senator Moore, yes. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes.
Senator Claxton, yes.
So that's unanimous of those present.
Yes.
So Senator Diamond, thank you for your advocacy. Thanks for putting this bill in early in the process to nudge things along. I think that contributes, made a significant contribution to this conversation.
Thank you, Mr. Chairman, and thank everybody on the committee. I think that was a very appropriate thing to do, and I appreciate your time you gave to my bill. Thank you.
Thank you. All right. So Are there further questions or related to either 1755 or 1960 that anybody wants to raise? Then I would entertain a motion. Senator Moore.
Senator Clapson, before we go for the motion, I guess what I'm thinking is, I mean, I believe that the governor's bill LD 1960 is very thorough and very complete, and there was a lot of negotiating going on with that. What I'm wondering, or what I'm hearing, is that having a membership on the Child Death and Serious Injury Review Panel would also be advantageous. So I'm wondering what the thoughts are of the committee of maybe taking that section from 1755 and putting that into 1960.
I'm seeing some head nods. Do you want to make that as a motion?
I can, but Representative Javner has her hand up.
Yes, Representative Javner.
I'm sorry, I have a question. If we could just hear from the administration on how they feel of adding that to 1960 before we make an amendment to that.
Sure. First, we'll invite Beth Bosang to step up if you'd like, and I'll bring in Molly. Welcome, Beth.
Good afternoon, members of the committee. Thank you for this discussion and having us join. That is, to my recollection, one of the few items that I don't think we covered in our various conversations with the ombudsman over the course of our discussions about how to best strengthen that office. But so, we hadn't taken a position, but we'd certainly have no objection, based on what the ombudsman's comments were this afternoon. It sounds like there's perhaps some reciprocal benefits to that information sharing and getting a broader view of issues going on in our child welfare system. So we'd have no objection.
And that language would be the ombudsman or a designee from that office. Okay. Senator Moore, did you have your hand up again or still, or?
Well, I was going to go ahead and make that motion that we pass LD 1960 as amended by adding that section from 1755 to 1960.
Second.
So the second was by Representative Meyer. Thank you for making the original motion, Senator Moore. And then I see a hand up from Anna.
It's just to be clear that it's section 1 and section 2, that section 2 of 1755 relates to section 1. It's just making sure that you know.
Yep. Any further discussion of that consideration? There is currently on the floor a motion ought to pass as amended, the amendment being the addition of a seat on the death and serious injury panel for someone from the Ombudsman's office. I'm not seeing any other hands or questions. Representative Perry did you want to say something? We can hear you now.
Oh, you can hear me now.
We can hear you now.
I'm sorry, I'm trying to make changes. I've got two committees I'm trying to be in at the same time. So I apologize for that, but no, I have, what got brought up was what I was hoping to see. So
yeah,
thank you.
Good. All right. So not seeing any other conversation, discussion hands, I'll turn it over to Karen to run the vote on LD 1960. Ought to pass as amended, the amendment being the addition of language that would have someone from the Ombudsman's office have a seat on the death and serious injury panel.
All right, Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
Yes.
Representative Lemlin, yes. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci. Senator Baldacci is absent. Representative Perry.
Yes.
Representative Perry, yes. Representative Javner.
Yes.
Representative Javner, yes. Representative Madigan.
Yes.
Representative Madigan, yes. Representative Craven.
Yes.
Representative Craven, yes. Representative Connor. Representative Connor is absent. Representative Griffin.
Yes.
Representative Griffin, yes. Senator Moore.
Yes.
Senator Moore, yes. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes.
Senator Claxton, yes.
So that's unanimous of those present, with some folks with other obligations right now. So that would bring us to a consideration of 1755. Anybody have a motion related to that? Yes, Representative Meyer.
Thank you, Mr. Chair. I would move LD 1755 ought not to pass.
And I'll second the motion.
Seconded by Senator Moore, original by Representative Meyer. Karen, is your hand still up, Senator Moore, because you want to make a point, or you want a second?
I just want to make a comment that we appreciate, all of the efforts that Senator Dill and Representative Curry are doing in the child welfare systems. And I mean, it's very heartfelt, for all of the different portions of it, and strengthening the ombudsman is such an important issue or topic that we really appreciate their work in that, or I do.
Okay, then I'll turn it over to Karen to run the vote on the motion ought not to pass.
Thank you, Senator.
1755.
Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
Yes.
Representative Lemlin, yes. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci. Senator Baldacci is absent. Representative Perry. Representative.
Yes.
Oh, there you go. Thank you. Representative Perry, yes. Representative Javner.
Yes.
Representative Javner, yes. Representative Madigan.
Yes.
Representative Madigan, yes. Representative Craven.
Yes.
Representative Craven, yes. Representative Connor. Representative Connor is absent. Representative Griffin.
Yes.
Representative Griffin, yes. Senator Moore.
Yes.
Senator Moore, yes. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes.
Senator Claxton, yes.
So that's unanimous of those present. Now the vote's been cast. I'll make the comment in support of what Senator Moore did. It feels to me like significant portions of 1755 were just incorporated in the governor's bill, and certainly the intent for greater independence. So we're grateful for anything that helped move the needle and make us a little closer to where we want to be. I want to thank Christine Alberti for the work that you did in the various efforts to bring us to a more solid footing for your office. And I hope you enjoy adding staff.
Thank you so much, Senator Claxton, and thank you to everybody so much for your support. I'm really excited.
Very good. And thank you, Beth Bosang, for being here and answering questions about the governor's feeling about the amendment. So appreciate that. And Molly, you got off easy, but we'll have questions later. So Senator Diamond, we have some changes coming in the Ombudsman's office if we can get this thing through the chambers. So
Yeah. Well, I'll do all I can to help. Just let me know what you need. And thanks again for doing such a great job on this important piece.
I knew you'd do that. So, all right, people. So that'll conclude those considerations, those three bills. Any questions? Karen, you have a quizzical look on your face. Okay.
Sorry, sir.
No, that's okay. You can have a quizzical look. I just want to make sure if there was one, I had a chance to ask
No,
about it.
nope. Thank you so much.
Okay. So we'll go back to Anna and consideration of, why don't we just go to 1773 in the order in which they're published?
Okay. Let me just find that one. Okay. 1773. Right, I don't know why I can't see the people, but it's really very annoying. Does anybody have any ideas about why I have that happening?
It probably has to go up to the view in the very upper right-hand corner. You see that?
No.
Put it on gallery.
I haven't got a gallery. That's the problem. It's disappeared.
You don't have view at all?
Nope, nope, nope. Oh, well.
We'll tell you.
Just
if you
remember,
need-
I'm flying blind. Okay. So 1773, and this does include a little bit about 1869 as well. So 1773, this is the bill that's related to the settings rule, the main care rule pertaining to home and community-based service waiver programs and person-centered planning, and the settings. And the original bill and the amendment that you received from the sponsor, which I can also put up in a minute, designates the rules adopted by the department related to the global settings rule as major substantive rules. In the amendment, they're making the global settings rule major substantive in the future, but allowing the current rule to remain in effect. I'm going to concentrate more on the amendment. The amendment also prohibits the department from enforcing the rule that has currently been adopted until January 1st of 2023, and requires establishing a stakeholder group to simplify the process and documentation of evidence requirements to demonstrate compliance with the settings rule, and assess need for additional funding for the settings rule remediation grant program. It would require that group to meet monthly and report to the Health and Human Services 2 years in a row. 1869 is a concept draft, and the bill proposes to require the department to provide timely updates on the new rule for the Medicaid home and community-based services waiver spending plans for enhanced FMAP using funds provided under ARPA. And the rule also proposes to require the department to provide consistent and accurate information regarding the spending plan to providers through its communication portal. So it is a concept draft, so you would need language if you want to move forward. So you heard from the department, and I'm sorry, this is more summary of testimony than I would normally do. I'm just trying to keep track of where all the pieces are. So you heard from the department on 1773 that there are a number of concerns if the bill becomes law, that Maine could miss the federal compliance deadline, which is the 17th of March of 23. It could jeopardize federal funding for home and community-based services, and we could also miss deadlines in a settlement agreement between the department and the Federal Department of Justice, and there may also be issues with renewing the 1915C waivers with CMS. They said that they had a stakeholder advisory committee that was made up of family members, providers, advocates, and others that has met at least quarterly since early 2019, with also monthly provider meetings for technical assistance. Over 90% of the providers have submitted transition to compliance plans, and the department did recently extend the state compliance deadline from the July 31, 2022 date that was in the rule to September the 30th of 2022, reduced some remediation expectations for non-residential settings, and reduced some of the documentation required for compliance. Paul Saucier's testimony includes the funding timelines and backgrounds for the setting rule that I didn't want to repeat here. The deadline of almost 6 months before full compliance, so the date that's in the rule for compliance and then the federal full compliance date, allows for intensive work with providers who have not yet received compliance. One of the issues is that the department can only enforce a rule that has been adopted. You also heard from the department about 1869, about the proposed grant funding, and that CMS has approved the plan to assist providers with settings rules remediation costs. And the public hearing was prior to the scheduled listening session with providers that was scheduled to be on the 4th of February. So that hadn't happened when you had the public hearing yet. You heard from Maxby and the providers that they support the settings rule, but they're concerned about the cost of compliance, the extent of documentation. There was a request for, I don't know if I can say that word, attestation. I know what it means, I just can't say it. Instead of photos for some of the aspects of the rules, for example. They complained about errors in assessment and also the rule going beyond the state rule going beyond the federal rule. There were concerns specifically expressed about LOC's requirements for proximity to services, lack of transportation, and lack of staff, especially if residents want to go to different places from each other, and also about the membership of the stakeholder group that the department had. There were concerns that the cost of compliance, for example, the increased staffing and training costs, is being considered to be outside of the scope of the rule, and they requested 2 phases. There were some requests for 2 phases of implementing the rule, the first phase of implementing the federal rule and the second phase of implementing the parts that exceed the federal standard. And then there was an issue with the department adopting the rule just before the bill was advertised. You heard from SUFU and some of the other self-advocates that they support the settings rule with opportunities for rights and access to community and choice. And so those folks were opposed to the bills. And then you also heard from Disability Rights Maine, who I believe are here, and also the Developmental Disabilities Council, that most of the global rule is verbatim from the federal rule, and that there were 4 ways in which it deviates. Definitions that individuals should be free from restraints, choice of provider limited to main care providers. The department has authority to require day or work programs to be physically accessible, have access to food, and the person determine the activities and schedule at those programs. And they also mentioned that Maine is one of the last states to receive federal approval of its initial state transition plan. And there was a request from Alan Cobo-Lewis that all of the HCBS rules should be made to substantive. And then some of the drafting issues, I did actually correct this in Representative Craven's amendment. The language in the bill refers only to home and community-based services for adult main care members with a physical disability or elderly receiving services under the waiver. There's no reference to intellectual disability, brain injury, or other related conditions. So just as an example of the language that is used in 34B to refer to these folks is for each home and community-based services waiver from CMS in which the state participates. What I did in the meantime was just to take out the word physical because disability would probably do the trick. The amendment refers to the department not being able to enforce the rule that has been adopted until January 1st, 2023, which is one of the things they're asking for. This would mean that the entire rule can't be enforced. I don't know the answer to this question. You would have to ask the department and the providers, but are there pieces of the rule that need to be in effect now that must be done ahead of compliance? Because this language would mean that no part of the rule could be enforced before the 1st of January 2023. And it's not entirely clear to me that the department wouldn't still have to go into rulemaking anyway to make those dates match. But I was reminded that the department were able to extend the compliance date by a couple of months without doing that. So maybe that's not an issue, but there is an issue. There could be an issue with not being able to enforce any part of the rule. And this isn't a drafting issue. This is just because I'm going to beat this drum until everybody hears it. You heard a lot of testimony around asking for the department to make the rule a major substantive because it's a big deal. Well, that's a dictionary definition of major substantive, and the legislature determines whether the rules are routine, technical, or major substantive, which is what you're trying to do here, of course, is to, or rather what the proponents of the bill are trying to do is to make the rule major substantive. But we can't say that the department made a rule as a routine technical rule that should have been major substantive, because that's not how that's not how those main care rules right now are written. So I just like to beat that drum because, you know, it kind of, I just wish that we'd called it something else in law, because routine, technical, major substantive kind of implies little things versus big things, but really you decide it. It's about what's reviewed by the legislature and what's not. So I'll get off my soapbox now because it's kind of annoying, I know. The other thing I do want to bring up is, before I forget, is I want to bring up Representative Craven's amendment. So let me just find that for you. Oh, can you see that actually? Did
Yes.
I accidentally bring that up? I wasn't trying to do.
Well done.
I wasn't trying to do that while I was looking. That wasn't me actually. That was the folks that began with this. So this is Representative Craven's amendment. So it starts with the same emergency preamble that is on the bill, except that I crossed out physical disability there. This is the section that, this is taking the section that is in the bill and showing you the changes that they have made. And this is to make the rules major substantive moving forward. And then the next section is the part about making the rule that was adopted not be enforced until January 1st of 2023. And then she made some changes to the stakeholder group that are mostly sort of technical, but it does show that she's looking for a stakeholder group of 3 or more providers of home and community-based services, including those in section 21 and 29. This representative from an association representing organizations that provide services. This is Maxby, but we can't write Maxby. And then a consumer, a direct care worker, and representatives of a number of the offices within DHHS. The department would staff it. And then the purpose of the stakeholder group is to create an efficient and effective manner to simplify the process. I didn't play with that language because I wasn't quite sure what the intent was. I mean, I know what the intent is, but it's not written quite correctly. But and then simplify the process and documentation of evidence requirements to demonstrate compliance and for reviewing those standards. And then the stakeholder group would also assess the need for additional funding under the rule remediation grant program that you heard about. And if you have questions about, I can see that Director Saucier is there. And then requires monthly meetings beginning with June of 2022. And then there are 2 reports that would come to this committee in October 2022 and October 2023. And with that, I'll stop yakking.
Thank you very much. So I'll go to Representative Craven first, and then we'll hear from Representative Martin was here earlier. I want to give him a chance to respond to his bill. But Representative Craven, your 1773 is yours.
Thank you, Mr. Chair, and thank you, Anna, for all the work that you put into this. It looks like an endless back and forth, and so I thank you. I think that, in my opinion, the amendment seems clear enough, and I respect the department and their need to have really worked really hard and in a short timeline to do those things. But I think also that providers have suffered, not just through the epidemic, but also way beyond that, for lack of staffing and lack of funding, and that they would really benefit from having some flexibility from the department to allow them to get their feet under themselves and to be able to comply. You know, they've always struggled with trying to comply with CMS rules and state rules, because they are enormous. There are so many rules to comply with, and I am sympathetic to their dilemma for needing some time and needing some flexibility and needing some revenue to hire the staffing that's needed to do all of the compliance with the rules. And that's all I have to say at the moment. Thanks.
Thank you. So I'd like to invite Paul Saucier. Welcome. Can you speak to how this process is going in general, and to the representative's request for flexibility as much as possible?
Yes, thank you, Senator Claxton and the committee. The process, as Representative Craven mentioned, has been very concentrated in time, because we had lost a lot of time prior to this administration. But despite that, we're in a pretty good place since the rule has been adopted. I mentioned at the hearing that we had some providers that were resisting the process legally because they were right. We didn't have authority. They have now rejoined the effort. And so I'm pretty confident that by September 30th, which is the compliance date in the rule, that we will be able to get most providers to compliance. There might be a dozen or so that would still not be compliant at that point. But one thing I want to make clear is they would not be removed from the program at that point. The reason we need time between the compliance date and the federal date is to work intensely with the remaining providers who may not be compliant by then. And, you know, that could take the form of additional intensive assistance. It could take the form of a plan of correction in certain cases, but that's what we would be focused on after September 30th. January is just too late with only then less than 3 months to go to federal compliance. And, you know, in the unhappy event, and we're not expecting this, and we certainly hope it's not the case, but in the unhappy event that we should have a provider that is unable to comply, we need sufficient time to give that provider notice, to give the clients they serve notice, and so on prior to March. So, so for all of those reasons, I think that the timeline, which we extended by 2 months in the final rule, as Anna Broom noted in her summary, I think we've now got a process that will work. It will still be very tight, but it'll work. We also did share with providers recently. We have monthly meetings with them, by the way, and we shared that we are pulling back on the level of documentation that is required now. In terms of the future documentation, which is a completely legitimate interest of the providers, we're having a special meeting of our advisory committee. We do have an advisory committee in March to review what we expect the documentation requirements to look like in the future post-compliance. That'll be a much less onerous process because they will have achieved compliance, and we're looking at you know, what's the ongoing evidence or documentation to ensure ongoing compliance. We'll discuss it with the stakeholders at that March meeting. And we have to put it in our statewide compliance plan, which we will post for public comment in April. So if folks are not satisfied with the level of ongoing compliance documentation that we're proposing, there'll certainly be an opportunity, well, two really, one at the stakeholder group and then another formal comment period, and then we'll complete our transition plan and submit it to the feds.
Thank you for that. Can we also hear from Stacy Converse? Would you care to join us and introduce yourself?
Sure, I'm Stacy Converse. I'm from Disability Rights Maine, and I am a huge proponent of the HCBS rules and how they will transform services for people with disabilities. I am part of that stakeholder advisory committee, which is made up of many self-advocates, many parents, providers, all of whom have been giving their time up since 2019, really to make this a process that will benefit people receiving services and to address any concerns that anyone may have about how the process is working.
Thank you for being here. Senator Moore.
So that brings up a question, I guess, in my mind, in looking at the amendment, where we have that section 3 that establishes the stakeholder group. It sounds like we already have that in place and that they've been working with the department. And it sounds like it's going to continue. It's not over with. So do we really need that in the amendment?
Is that a question for me, Senator Moore? You're right. We have the stakeholder advisory committee that has all stakeholders engaged. They've been meeting quarterly, but they committed to stepping that up to every other month. And I'm sure they would be willing to meet more often if necessary. Our parent co-chair, Linda Lee, is very willing to do whatever would be required to make this process work. In addition to that, over the past year, we started having a special provider meeting monthly, which is more focused on technical assistance. And so in both of those venues, I'm confident we have the time and the people we need to address the providers' concerns.
So we really don't need to put it into statute, I guess, is what I'm thinking, or what I'm hearing.
Well, that's certainly our position. I mean, we're going to be having these meetings regardless.
Thank you. Representative Zager.
Thank you, Mr. Chair. I think Senator Moore raises a good question. I'm wondering if we might hear from Laura Cordes, who I believe is in the among the attendees from MAXP.
So we'll move her in and hear from her. Welcome, Ms. Cordes.
Good afternoon.
So did you have a particular question, Representative Zager, of Laura?
Well, really just to reiterate what Senator Moore raised.
Yes.
I'm interested in if you feel like the process that is underway and is planned to continue meets the needs, to ensure that the process is not so onerous that it impedes the actual care of the folks that we're all wanting to serve here.
Thank you. We came to the proposal of a stakeholder group as certainly proponents of the HCBS goals themselves, but having a concern about provider requirements and documenting the transition to compliance process. And what we really felt is just a lack of opportunity for more meaningful collaboration with the department about the process. I think I would suggest to the committee that it's a situation of both and. We participated in the stakeholder groups, the innovation group, the community membership group. We have providers that sit on the quarterly HCBS advisory committee. And I know, there were certainly times throughout the pandemic that the provider participation, they were pulled away to be doing shifts to keep people supported on the front lines. And because it's been raised to me that, how did it come that, our needs with all these groups weren't met? And I would say, that in these groups, it was just never a place to be able to focus on really critical areas for providers and using their expertise to talk about which requirements and tools that are being put in place now to document and demonstrate compliance would need to be required in an ongoing way. And I appreciate Director Saucier just referencing that they are very legitimate concerns, especially when we want to be effective and efficient stewards with Medicaid dollars to hold up services and to keep them in place. And, thinking about, okay, staffing levels now and requirements that are being made, what does it look like next year? What investments do we need to make in training programs to align data entry, billing, and auditing systems? And that's, behind the scenes to hold up these services every day for thousands of folks in Maine. And we wouldn't be requesting it. We don't want to waste time, certainly not our own, in another meeting. But if there wasn't a need for it, we certainly wouldn't be advocating for it.
Does that answer your question, Representative Zager?
So if I understand, Ms. Cordes, what you're saying is that you feel like you applaud and appreciate the outreach and the process that Director Saucier has outlined, but you still think that wouldn't be sufficient necessarily, that this bill ought to proceed nevertheless.
I think in good faith, hearing it new today, I'm so glad to hear that there may be more space and time made available, and that perhaps a shift in focus to asking, folks what needs to be discussed in this space. Because it's generally been updates about how, and it makes sense that it would be large updates about how the overall process for the state is going. But hearing that shift is very promising. But given the opportunity to ask for a stakeholder group, I would love to see that happen through this legislation.
Thank you very much. I appreciate it, Mr. Chair.
Thank you. Any other questions of our various resources we've identified so far? Or of anybody that we need to ask of? Yes, Representative Meyer.
Yes, Linda Lee, I believe, was a co-chair, a parent co-chair. Just wondering what her thoughts are.
Welcome, Linda Lee. When you unmute, we want to hear from you.
Yes, that would be helpful. Thank you for inviting me to be here today. I speak as the parent of a 23-year-old who receives HCBS services. I'm his shared living provider. I'm his mother, his guardian. And when I was asked, I guess at the beginning of 2019 to become the co-chair of this, I had no idea. I followed along the HCBS process because, like Stacey says, I firmly believe that this whole HCBS process is about bringing people with disabilities a civil rights issue, that they deserve to have the rights that we have as regular citizens in the community. They deserve to have choices about where they live, about when they want to eat, about who they have as their roommate, that people with disabilities have these same rights as do the rest of us. So I agreed to do it because I believe in this so strongly in my heart. And so from the start, 19 members were appointed by the commissioner, 5 of whom are self-advocates, 5 of whom are actually providers. We also have 3 parents, an attorney who's here, Stacey, the Associate Director of Maine Developmental Council, the Program Coordinator for Brain Injuries, 1 representative from Maine Developmental Oversights, 1 Ombudsman Program Manager, 1 Behavioural Analyst. And so from the start, everyone has been able to, the chat is kept open all the time so that people can ask questions. The people can raise their hand at any time. Given that we have self-advocates there who can barely speak, we try to keep the meeting in such a way so that it's open for anyone at any time to speak. And so my role in this is that I welcome everyone every time, remind them why it's so important that they are there as stakeholder advisors for the state, that's really important. The second thing I always remind people at the beginning of every meeting is that these federal changes didn't get pulled out of a hat by the federal government, but they were based on the input of over 2,000 individuals, including those with disabilities, over a 5-year period before 2014, when these changes came into being. These are not new. We were told to do this in 2014. I also remind members every time that the state is forced to comply with these rules by March 2023 if they want to keep on getting the money to support the HCBS services, which totals over 400 million in our state. Over 66% comes from the feds. And so my role as a co-chair is we always have a pre-stakeholder advisory committee meeting, which sometimes lasts between 1 to 2 hours, where we discuss which topics are of the highest priority for the next meeting based on the HCBS timeline. We discuss what materials should get sent out in advance so that the members have time to go over the materials in advance of the meeting. We decide on a pre-planned question on a chosen topic for that week for people to discuss, which is provided to the members in advance of the meeting. And we decide on other speakers or information which could help enlighten the chosen topic. For example, the topic of community involvement or the topic of work, which is a big issue. And the 5th thing that I do in the meetings is I'm always trying to pull people, given how many different cognitive functioning levels we have, different processing speeds we have, I try to pull people into the discussion. I agree with so many things that were said today regarding. Laura talks about that even though there are 5 members on the committee and that are providers, even that it isn't a place, it's a place where of course they can bring forward their questions and all the rest. And actually out of this group, it was decided that this department would start holding monthly meetings. And at one time there were every 2 weeks meetings solely with providers. And they've provided this department have provided over 10,000 hours to providers to help them with those technical issues. So from my perspective, we have an amazing group of people who dedicated their time, who don't get paid to do this, who don't get paid even when we were in person meeting, driving to Augusta. No one got paid to go there for travel expenses or to pay for caregivers, which I have to do in my sense, which goes to show the level of commitment that individuals have. Self-advocates who had a great difficulty getting around even got themselves those meetings in Augusta. And that's without any recompense or any promise of it. We knew up front we were not going to be paid to do this. So we're all doing it from our hearts because we believe in the process. Thank you for your time.
Thank you for your efforts and your commitment.
Thank you.
Are there any other questions of the folks we have available as resources at this point? I also noticed that we've been joined by Representative John Martin. Sir, would you like to speak to LD 1869 and the analysis that Anna put forward?
I think that works. Hang on.
We had you unmuted there for a minute. We can't see you, but we heard you.
There. Okay, not a problem. Yeah, I think that outline really would work well. And I think I would support the changes the department is going to do with that.
So related to your bill, what I heard was a request for amendment that we could work on. Is there anything you want to put into your bill that at this point is a concept draft?
Yes, there was a letter that should have come in from Jerry Petroselli, and I don't know if the staff has received it, but I don't have it.
Anna, does that ring any bells? Did you get a letter?
I have to check in the file. I know we got one from him for 1773, but I don't know
Okay.
that we did.
Well, I got an email from him saying he's forwarding it to the committee, directly to the committee.
And that was specifically to your bill 1869?
That's correct.
Okay. All right. So we're missing a key piece of that bill for right now. And that leaves us really at this point. But thank you, Representative Martin, for being here and clarifying that. Next, that leaves us with 1773. Are there other questions about 1773 for right now? Yes, Representative Zager.
Thank you, Mr. Chair. I feel like there's been movement in a collaborative direction since this process began some months ago, even years ago, and I feel like the committee is very attentive to the importance of ensuring that that we continue to provide these services, that we don't endanger $400 million of federal funding, but that the process and the provision of these services are not onerous, excessively administrative, and so forth. And so I'm wondering if we could just encourage the process to proceed along with scrutiny through a letter of some sort, as opposed to legislation. I would offer that to the committee as a way to remain engaged, asking the Director Associate's office to report back on how this these discussions proceed, so that we can achieve what we want to achieve.
So that would be the core of your letter. Right. And okay. Any other comments related to this bill? Yes, Representative Meyer.
I could support what Representative Zager is offering.
Representative Javner?
Thank you, Senator Claxton. I definitely would concur. I think that, this has been a very important conversation, and any legislation in the future, as we keep accountable the process of what's happening, would be very welcome, of course, in the next legislative session.
Representative Javner, would you consider it a friendly amendment to include advocates and providers in the update from, in addition to Director Saucier?
Absolutely.
Okay. Do you want to make a motion, Representative Zager?
Sure, Mr. Chair. Thank you. I move that we send a letter as outlined to include the providers as well as the department in the report back, with the committee able to report out legislation, and then would move that 1960 ought not to pass.
Thank you for that. There's a motion.
Correction. 1773.
1773.
Looking at the wrong spot on my
I knew I heard that number before somewhere. Representative Craven?
Maybe you need a second on that before I make my, before
Okay. So
I'm not seconding it, but.
right. Wait a minute. Let's get a second. You're right.
I
Motion was
second the
made-
motion.
You second the motion, Representative Meyer? Okay. Made and seconded. Representative Craven?
Well, so thank you. I have to thank the committee for the amount of time you spent on this and the department, and I definitely want to thank the providers for all of the work that they do and the important work that they do in this arena. And I'm very grateful. I won't be supporting the measure, but I definitely understand why it's going this way. So thanks.
Thank you. Anna, before we do any voting or get further down the road.
I just want to clarify that you can't have a report out a bill authority from a letter, but you are going into first session, which means that any legislator can put in a bill in first session, but there's no authority to put in a bill that comes from a report that comes from a letter. So I just want to make sure that you understand that.
Okay, that's on you, Representative Zager.
I appreciate that insight, and I guess I was. Any legislator could include a concept draft, but would the committee need to have? Could the committee report out in the first session of the 131st without an individual legislator doing so?
Well, you'd have to get a joint order. You can report out a bill and that's pursuant to a study, but the study has to be pursuant to the law or resolve or something like that. So it can't come out of a letter. But yeah, you can put in a sort of a placeholder bill on your own, or you can ask for an after deadline bill. So those are all the options, but none of those things are guarantees. What is a guarantee is you putting in your own bills after you get elected and before cloture, for whatever those things are.
Sure. Thank you.
Any other questions or comments? The motion on the floor is ought not to pass with a letter. And the letter to be drafted with Representative Zager and Anna's work to reflect what we can do as a committee in our letter. Is that enough for you, Anna, to start the process?
Yeah, I have some idea of what you want, but we also draft the letters at the end while you're all in the chambers debating. So there'll be plenty of time for me to talk to whoever. And it sounds like Representative Zager would be taking the lead on that. So yeah, that's fine.
Good, thank you. All right, in the absence of any other comments related to LD 1773, the motion on the floor is ought not to pass with a letter being sent to the department I will turn to Karen for collecting the vote.
Thank you, Mr. Chair. Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
Yes.
Representative Lemlin, yes. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci. Senator Baldacci is absent. Representative Perry.
Yes.
Representative Perry, yes. Representative Javner.
Yes.
Representative Javner, yes. Representative Madigan.
Yes.
Representative Madigan, yes. Representative Craven.
No.
Representative Craven, no. Representative Connor. Representative Connor is absent. Representative Griffin.
Yes.
Representative Griffin, yes. Senator Moore.
Yes.
Senator Moore, yes. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes.
Senator Claxton, yes.
So that's 10-1 of those present.
Yes.
Thank you very much. Thank you, Stacy Converse, for your perspective, Linda Lee for sharing the work that you're still doing, and thank you for doing it. And Laura Cordes for your ongoing advocacy.
Thank you.
So, yes, Anna.
I just want to clarify, Representative Craven, you're looking for your own amendment, vote to pass as amended. Is that your minority report?
Yes.
Thank you.
That was a gentle way of reminding me yet again that I forgot the minority report. Thank you for being gentle, Anna. Representative Meyer.
Thank you, Mr. Chair. Can we circle back to Representative Martin's?
That's where I was going next.
Okay, thank you.
Yeah, so at this point, none of us have seen the amendment that I'm aware of, and we haven't had a chance to consider it or have it analyzed. So it would seem most appropriate to entertain a motion to table at this point and get it on the agenda as soon as possible. Were you thinking otherwise, Representative?
No, so moved.
Motion to table,
Second.
seconded by, I didn't see the green light fast enough. Okay, Representative
Representative
Javner. Thank you.
Javner.
Yeah, thank you. So motion to table has been made and seconded on LD 1869. I think historically how we've done this, we can do this with a show of hands. All those in favor of tabling it. That is unanimous of those present. So we have tabled your bill, Mr. Martin. We'll try and chase down that letter and we'll get a work session scheduled as soon as we can.
Thank you. And I've already called his office as well.
Okay, very good. All right. So that brings us about an hour and a half in. It's usually at this point that I get poked by Representative Griffin in the chat box to say, can we have a little break here? Representative Perry, your hand's up. Representative Perry, your hand's up and you're muted. So we'll come back to Representative Perry when we reconvene at 2.
Hello.
Oh, there you are.
I for some reason I lost sound and everything on the thing I was on, but can I vote yes?
Oh, you're two places. You're also on my screen
places.
having your
I
hand up
believe-
in another place.
Yeah.
You must
Here we
you
go.
must have logged back in. Yes,
I
you
did.
feel free to vote, Representative Perry. That's okay with us.
Yeah, yes. That's the vote.
All right. Did you get that okay, Karen?
Yes, thank you.
Okay.
There's
Now
our
that Representative Perry is back with us, why don't we take a break for a 6-minute break and come back at 2:35 and resume working. Okay, so we'll resume this afternoon's work on our list of bills. Why don't we go to LD 533 next, Anna, if you would.
So let me just, all I have for that. All the people are there. I logged back out and logged back in again, and look what happened. I can see the people.
People came back.
The people came back. Can you, however, see my email?
We can. I have a magnifying glass. So I'm all set.
Oh, I don't know if I know how to make
You
it bigger.
can't do anything about that. No, you're
Okay.
good.
All right. So this is this is what you so this is the bill that has some pilots for the ECCP, and the bill would take it statewide. And so that was a concept draft, but basically the amendment, in my understanding, would be funding. So we asked the department what for an estimate on what it would cost to expand 533 or the ECCP statewide. So this is obviously from Molly, and Molly is here. Any more sort of specific questions are a little bit well over what I will understand, but this is a sort of a basic estimate. It doesn't tell you exactly. I mean, what we would do is, if you want to move forward, is it would be a bill with an appropriation, and obviously Luke would have to work with the department for the appropriation, but this gives you some indication or estimate of what the department thinks it would cost. Actually, I'm not sure you can see the bottom. Whoops, went a little bit too far there.
Oh, it's there.
Yeah. So the 3.717 million. Can I stop sharing, or would you like me to leave it up?
No, that's good. So I was checking to see if Senator Breen is in the.
She is there, Senator.
There she is. Okay, we'll bring her in. Molly's already here. As soon as Senator Breen makes it through the wormhole.
She hasn't quite yet accepted promotion, Senator.
Here we go. Hello, Senator.
Greetings. I'm sorry, I was talking to a heating guy who's in my house.
That's an important consideration these days. So basically, we understand this to be an appropriations bill to expand existing programs that were initiated as pilots.
That's correct. The pilot programs have started, and to take it statewide, we're going to need some additional funding. And I just think, as I said at the public hearing, we already know this is an evidence-based model, and certainly with the pandemic, families and young children are under more stress than when we started. And I think if at all possible, we'd just like to take it statewide as, sooner rather than later.
Okay. So given what Anna had to say and what Senator Breen has just said, are there any questions of either of them? And then we'll go to Molly, and this represents your department's best first pass at what this would require.
Yes. Thanks.
Okay. Any questions of, yes, Representative Meyer?
I would like to make a motion
Feel free.
that LD 533 ought to pass as amended.
Second.
Second from Representative Craven. made and seconded. Any discussion? Not seeing any. Karen, it's on you to collect the votes. Representative Javner.
I apologize. Could I just perhaps ask for just a 5-minute caucus with my?
Sure,
with my
of
people?
course.
Just have a couple questions for them.
Okay, so we'll reconvene in 5 minutes, which is 2:48.
Thank you.
We'll see who's here. So we'll resume this afternoon's hearing of Health and Human Services. Did you have a chance to accomplish what you wanted to, Representative Javner?
Yes, thank you very much, Senator Claxton.
Don't hesitate to ask. That's the understanding. All right. Any other questions before we collect the vote? Any other requests? The motion on LD 533 is ought to pass as amended. Karen, could you collect the vote?
Certainly, Senator. Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
Did you say it's ought not to pass as amended?
Well, I don't know what I said. What I meant to say was ought to pass as amended.
There you go. Yes, I'm a no.
Representative Lemlin, no. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci. Senator Baldacci is absent. Representative Perry.
Yes.
Representative Perry, yes. Representative Javner.
No.
Representative Javner, no. Representative Madigan. Representative Madigan is absent. Representative Craven.
Yes.
Representative Craven, yes. Representative Connor. Representative Connor is absent. Representative Griffin.
No.
Representative Griffin, no. Senator Moore.
No.
Senator Moore, no. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes,
Senator Claxton, yes.
that's 6-4 of those voting, and Representative Madigan would like to record her vote.
Yes.
Representative Madigan, yes.
So that's 7-4 of those voting.
Yes.
Thank you. So
And-
I'm going to ask about a minority report.
Awesome.
That would be ought not to pass.
Thank you. Gonna have a big sign put up that says minority report over my computer. All right, so let's go up to 1765, Anna. And you're still muted.
Yep, this time I didn't forget actually, but usually I do. Okay, hopefully you are looking at 1765.
Yep.
This is an act to support childcare for working families. It's a department bill. This is a bill that removes the requirement for the Department of Health and Human Services to charge a minimum transitional childcare services premium for families who lose eligibility to TANF benefits as a result of increased earnings or an increase in the number of hours worked, or who request that their benefits be terminated. You heard from the department that transitional childcare is available to families at or below 250% of the federal poverty level who lose eligibility for TANF because of earnings, work hours, or by request. Most families pay 8 to 10% of their gross weekly income, which is an average of $103 a week. And the department is currently providing transitional childcare to 233 families. Current law requires a 2 to 10% premium, and there's no similar requirement for the childcare subsidy program. During the public health emergency, the department was able to suspend premiums for the subsidy program, but they couldn't do it for transitional childcare. The subsidy program eligibility is 85% of the state's median income adjusted for family size, so they are slightly better off than the TANF families. So you had questions about who pays the premium to the childcare provider, if not the family, and what the funding source is, and whether the folks on the subsidy folks are again paying premiums. OFPR preliminary fiscal impact statement that there's a minor cost increase to the general fund, and that any additional costs to the department to adopt the changes in this bill are expected to be minor and can be absorbed within existing budgeted resources. And then hopefully, did it work to change my screen there, or do I have to go in and out? Are
No,
you
you're
still
good.
Okay, so I'm not going to explain this, but you did get the memo, so I wanted to put it up on the screen. And it does say in here that somewhere in here, Molly, now I can't see it again, that the providers are made whole. All right, somewhere. Why can I not see this, Molly?
I think it's right at the, well, the bottom of mine, which is zoomed, but it's at the bottom of how TCC is paid. And yes, I know one of the questions is whether the waived fee is covered by OFI for childcare providers. So when we waive a fee, they don't have a financial impact, and that is true. So say the parent's fee is $50 a week. If we waive that, the benefit that OFI pays directly to the provider goes up by $50. So the provider sees no difference in what they should be receiving.
Thank you for that clarification. That was a question I asked. All right. Representative Zager.
Thank you, Mr. Chair. Does that mean that there's a fiscal note, or is there some sort of block grant or other mechanism to make up for that?
Yeah, so there is no fiscal note on this. Any fees that we decided to waive in the future would come out of that TANF block grant. So no general fund.
Yes, Senator Moore.
Well, it sounds good to me. I would make the motion of ought to pass on LD 1765.
Second.
And that was Representative Javner seconding. Senator Moore, the initial motion. Any discussion of this? I'm not seeing any. So the motion on the floor is ought to pass on LD 1765. So Karen?
Thank you, Senator. Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
Yes.
Representative Lemlin, yes. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci. Senator Baldacci is absent. Representative Perry.
Yes.
Representative Perry, yes. Representative Javner.
Yes.
Representative Javner, yes. Representative Madigan. Representative Madigan is absent. Representative Craven.
Yes.
Representative Craven, yes. Representative Connor. Representative Connor is absent. Representative Griffin.
Yes.
Representative Griffin, yes. Senator Moore.
Yes.
Senator Moore, yes. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes.
Senator Claxton, yes.
So that's unanimous to those present and voting. Thank you. I forgot to thank Senator Breen for bringing forward LD 533 and for getting an amendment to us with a calculation of the fiscal note. So thank you for that. I was remiss before she got converted back to an attendee. All right, so that would bring us to 1790.
All right, 1790. This is an act to ensure equitable geographic access to long-term care services in the department. The bill required that access to in-home and community support services for adults with long-term care needs to be equitably distributed across geographic areas of the state, and provides that at a minimum, providers must be available for telephonic or in-person meetings in order to provide services in every state, every county in the state. You did get an amendment from the sponsor requiring department staff to be available by telephone or in person to assist providers and surrogate in the administration of services. And the sponsor removed the rulemaking language because it already exists in that section of statute. So you heard about the downsizing of offices in rural Maine, making it difficult for people in those areas to get services and answers, and the lack of providers in rural areas. And you heard about the Healthy Living for Maine ACL grant to develop a network-led entity and community integrated health network to try and get at the issue of a lack of coordination between the department, community organizations, and healthcare. You did receive some neither for nor against testimony from the department that the availability of home-based care depends on provider capacity, and the department can't require them to serve specific geographic areas. And you were provided some information about staffing, that OFI is responsible for eligibility for long-term care services, but not the administration with providers. And there are eligibility units in Augusta, Machias, and Portland. And more than 10 years ago, there were 4 additional offices that were consolidated due to staffing limitations and infrequent requests for in-person assistance, with most interviews being conducted by phone. There are some requirements for equitable distribution across the state to the extent practicable that are already required in law. That language is both in the bill and the amendment, but it does already exist in law. And then the bill doesn't require, and I'm not sure whether this is on purpose or not, but the bill, it doesn't require DHHS in-person staffing across the state. It states that the bill states that they must be available for telephonic or in-person meetings. And I think staff is already available for telephone meetings. And you did actually get a slide in the LIFT presentation that you received last week about the average waiting time for call centers. So if you want to move forward with this, you need some more specificity, because it isn't quite clear to me how the bill itself solves the problems that you heard about. And I did just include a link to the ACL community infrastructure grant that you heard about from Gerald Quealy, because just because it was interesting and I ran into it. So if you're interested in that, there is a hot link available for that.
Very good. Based on that, any questions or concerns that this raises for anybody? I'm going to, yes, Representative Meyer.
Thank you, Mr. Chair. Just wondering if Ms. Bogart could weigh in on long-term care eligibility work.
Sure. And I'm not sure I've introduced myself this afternoon, so I will do that for the record. I'm Molly Bogart, Director of Government Relations for the Department of Health and Human Services. So the long-term care eligibility work done by the Office of Family for Family Independence is done in a separate track from your regular main care eligibility. And we have specialized teams that do that work. And I think from some brief conversations with the sponsor staff, I understand that is the eligibility work that they were most interested in. So as Anna mentioned, those teams are in Machias, I think Augusta and Portland, and they're available by phone across the state. I know Anna mentioned the call center wait times, and I did want to mention these again are different folks. When we're talking about those wait times, we're talking about the Wilton call center and the teams doing the regular eligibility. And we know that we have challenges with those wait times often. But this group, folks who call for long-term care eligibility are immediately directed to one of these specialists. And so that wait time is different. I would have to get you exactly what that wait time would be, but we expect that it would be shorter because of the dedicated teams that do this work. So I'm happy to elaborate a little bit more. Those folks are, of course, available by phone for anyone, anywhere in the state. And for logistical and team management reasons, we consolidated them into those 3 hubs so that they can be with their peers and have the support of a supervisor for this specialized work. But happy to answer any other questions you might have.
Thank you. Representative Perry, you had a hand up?
Yes, I'm really just trying to get a sense of exactly what they're asking for. And I really wasn't sure really what this bill is really asking for. It almost sounds like they want a physical presence that is more diverse. Or is it that they want more call centers? Is there a dissatisfaction with the service? Molly, can you enlighten me on this?
I'm not sure that I can speak for the sponsor, unfortunately. Yeah, I can speak to what we have and how we do it now, but would have to defer to President Jackson.
So let me ask it another way. Do you have metrics that you're following that would tell you how the department's doing with waiting times and handling these things? The testimony we heard was obviously from worst case scenarios, the people who got bounced around a bunch, but I don't know whether that's 1% or 30%. You all have metrics that track how you're doing in terms of customer service.
Yes, yeah, we do have call center metrics for each of our teams, and I could get more specifics for the committee on those. If someone is looking to speak with a long-term care eligibility specialist in person, I can understand how they might not be satisfied by the fact that these folks are grouped in teams across the state. But our anecdotal experience is that very few folks need or desire an in-person meeting for this eligibility review.
Thank you. Does that come closer to addressing what you were trying to get at, Representative Perry?
Well, I guess so.
Well,
it would be nice to just get a sense, and I think you had mentioned this, Senator, of maybe what the service is doing, if there is a wait time. And I'm also getting the sense, and I guess this is the other thing, is are people with some of these questions being sent to the right place? Because I got the impression that they were going to many different places before they got to where they needed to be. And do you track that as well?
I'd have to talk with our OFI team about whether we track folks who report that they were routed incorrectly in our call system. I can imagine, folks call and say, I need to talk to somebody about main care eligibility. So then they talk to a, for lack of a better term, regular main care eligibility specialist, where it's then determined they need to go back to the long-term care team. Part of that is just a function of the inside baseball and folks coming for eligibility and their, perhaps, lack of specificity or understanding or whatever. I'm not sure if we'd have data to track that so much. Certainly if we received a complaint about that, we would know that, and we do all sorts of quality assurance checks on our customer service, but I'd have to talk to OFI about that specifically.
One other just comment or question, because I am sure people don't necessarily always know which way they're going, is there ability of the call center to narrow that down, ask those questions to find out exactly where they want to be?
Yeah, and that's part of one of the changes that we've made in the last couple of years is having folks speak to a sort of central hub before they get routed. And so they call, they get an answer relatively quickly, and then they say what service they're looking for, who they're looking to speak with, and they get routed to a call center. We know some of those call centers then have significant wait times. And so I just always want to remind folks that we're aware of that and constantly working to bring those down. But that routing process should be what helps folks get there. I imagine though that it's not a perfect process given Folks may not always know exactly what they're looking for. They may not know the sort of term of art that they should use to get where they need to go. And so our teams try to suss that out as much as they can. But, whenever you have humans involved, there's space for human error. And I'm sure that happens once in a while.
I think the committee might be interested, though, in seeing, say, a couple of key metrics and some indication of a few of the things that you were working on, or OFI was working on, to be more customer friendly when you get a chance. Okay. All right. So I'm not seeing any other questions about 1790. Any other comments? Then I would entertain a motion. Representative Meyer.
Thank you, Mr. Chair. I would move 1790 ought not to pass.
Second.
Second from Representative Javner. Any discussion of that motion?
I see Brenda Galantin. Is she here for this bill?
Oh, thank you for, I did bring, yes, I did bring her in. That was my intention, and to ask her what you've heard and what we should be doing if we can nudge things in the right way. Welcome, Brenda Glant.
Thank you. Good afternoon, Senator Claxton.
I'm not hearing you very well. Is anybody else?
I'm sorry.
There you go.
Okay, all right. So I was actually here for the next bill, but what I can tell you is, to be honest, we really have not had any complaints about OFI. So, I mean, I certainly could talk with my staff, but I have a little bit about this, and we were just wondering what the origin was. And I actually reached out to Molly, and I really don't have any more information, and we're just not getting complaints. So that's really all I have to add.
Representative Perry, I brought her in to get that comment, give her a chance to comment, and then I forgot to recognize her. All right, so you're welcome. And now, Karen, you can run the vote on LD 1790. The motion is ought not to pass.
Thank you, Senator. Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
Yes.
Representative Lemlin, yes. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci. Senator Baldacci is absent. Representative Perry.
Yes.
Representative Perry, yes. Representative Javner.
Yes.
Representative Javner, yes. Representative Madigan. Representative Madigan is absent. Representative Craven.
Yes.
Representative Craven, yes. Representative Connor. Representative Connor is absent. Representative Griffin.
Yes.
Representative Griffin, yes. Senator Moore.
Yes.
Senator Moore, yes. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes.
Senator Claxton, yes.
So that's unanimous of those present voting on this LD 1790. So now, Anna, we can go to 1791.
So I'm going to make this one short for you. This is an act directing the department to provide notice to hospitals of nursing facility closures. The bill requires the department to provide notice of a nursing facility's voluntary closure to all hospitals that are, actually, I believe it was all hospitals in the amendment from the Maine Hospital Association. They also added in some language about the voluntary closure pursuant, sorry about the two pursuants, that's not the sponsor's fault, pursuant to section 1822, which is the 30 days, or the comparable CMS regulations, whichever notice is received first. So there was some, I'm not going to talk about the testimony because you have an agreement. So I'm just going to pop right on I'm not sure it's most appropriate for me to share. I can share it, but I'm not sure that you really want me to speak to it. I can, but you do have the folks that worked on this. So I can keep the share up, but you might want to have different people talk about it than me.
Sure. And I understand that Jeff Austin was part of that conversation, and Angela Westhoff was a convener. And who else am I leaving out? Who?
Bill Monteo, and
Oh, yeah, that's right.
And
Yep.
also Brenda is here for this,
Yep.
and Molly.
Yeah. So they're all coming into panelist status. So I can't see everybody right now, but I'll defer to whoever wants to go first to introduce the amendment or the agreement. Sorry about that, agreement. Bill, I'm not hearing your audio. I see it looks like you're talking.
Sorry, Senator.
There we go.
Hello, Senator Claxton, Representative Meyer, and members of the committee. I know you've been provided with the summary, but essentially the agreement that we all came to was following along the federal guidelines, where when there's a receipt of a nursing home, a voluntary nursing home closure, licensing, our office will remind, and this will be a written reminder to the nursing homes of the federal regulation and the intent in the federal regulation that the nursing home administrator notify other entities impacted by this closure, including hospitals. We are then going to draft an internal policy, which we're actually working on now, a policy and procedure for receipt of any voluntary nursing home closure plans, to include a requirement in that nursing home closure plan for the nursing facilities communications plan to the Maine Hospital Association, and the Maine Hospital Association will then provide notice to the hospitals. This notice to the Hospital Association will be at least 30 days prior to the closure, but not before notice to the residents and staff within the facility. And the agreement is really a pretty good one, in that Maine Healthcare Association will provide education to and assistance to the nursing home administrators. The Maine Hospital Association will provide the outreach to the hospitals, and we also included a request that the Hospital Association ensure that the hospitals understand or educate the hospitals on the need to really have an internal policy or procedure to ensure that once they get this information, it gets to the discharge planners and the people that need it. So it kind of closes the communication loops on both ends and addresses the intent of the bill.
Very good. I see Angela Westhoff. Let's invite some of our guests to have something to say if they want to. Angela Westhoff, did you want to speak to this at all?
Yeah, good afternoon. Thank you, Senator. I would just echo Bill's comments. I think it was nice to convene a group and achieve a consensus recommendation, and we support the proposal, the letter, the memorandum that you have before you. Thank you.
And Jeff Austin, did you want to say something?
We're good.
Thank you for your succinct testimony. Brenda Gallant, did you have anything else you wanted to add?
Well, we think it's a very good solution, and we were pleased to be part of the group and have everybody together to work out a solution that will be effective. And we've been through a number of closures, and we think this is a very good outcome, the plan that we've come up with. So we're pleased with it. So
great. Representative Perry.
My question is, with all of this, does this also include, I guess, what we tend to call the PNMIs we call assisted living? There are some assisted living facilities that come very close to being a nursing home, and have some of the same effects.
This does not, Representative Perry, because the PNMICs and the residential care facilities that you refer to are not subject to the CMS closure notifications. And the rules are substantially different for them. So no, it does not address that. I'm not opposed as the director of licensing to providing education and outreach to those facilities regarding the closure, but any change would require a change in rule for the PNMIs.
Thank you.
Representative Gavner?
Thank you, Senator Claxton. Thank you, everyone, for your hard work. It's very, very welcome and necessary. I'd like to make a motion, if I may.
Please.
Ought not to pass on LD 1791.
Second.
Second.
Second was Representative Meyer and Representative Lemlin, both seconded about the same time. So the motion is ought not to pass. Additional comments, questions? I don't see any. So Karen, it's your turn again. LD 1791. And the motion is ought not to pass, made by Representative Javner, seconded by Representatives Meyer and Lemlin.
Thank you. Representative Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
Yes.
Representative Lemlin, yes. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci. Senator Baldacci is absent. Representative Perry.
Yes.
Representative Perry, yes. Representative Javner.
Yes.
Representative Javner, yes. Representative Madigan. Representative Madigan is absent. Representative Craven.
Yes.
Representative Craven, yes. Representative Connor. Representative Connor is absent. Representative Griffin.
Yes.
Representative Griffin, yes. Senator Moore.
Yes.
Senator Moore, yes. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes.
Senator Claxton, yes.
That is unanimous of those present and voting. I want to add or echo what Representative Javner just said. It's a great solution and much better than statute. So thank you all for your efforts, and it's amazing what you can get done when you sit down together. I'm looking forward to that when that happens. Thank you. All right. I think that means we're supposed to look at 1769, and then I want to loop back on an outstanding bill briefly at the end. So 1769.
I have nothing for 1769. This is the V9 bill that just changes the word state to department. It has no fiscal note. We just heard it 2 days ago.
Representative Meyer.
Yes, I'd like to make a motion that LD 1769 ought to pass.
I'll second the motion.
Seconded by Senator Moore, made by Representative Meyer. Do we want to have a passionate discussion about that change? No, let's vote it.
Hearing no passionate discussion.
Right.
Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
Yes.
Representative Lemlin, yes. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci. Senator Baldacci is absent. Representative Perry.
Yes.
Representative Perry, yes. Representative Javner.
Yes.
Representative Javner, yes. Representative Madigan. Representative Madigan is absent. Representative Craven.
Yes.
Representative Craven, yes. Representative Connor. Representative Connor is absent. Representative Griffin.
Yes.
Representative Griffin, yes. Senator Moore.
Sorry about that. Yes.
Senator Moore, yes. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes.
Senator Claxton, yes.
So that's unanimous of those present. That's another good one. Thank you. The bill I wanted to loop back to, we voted on it 48 hours ago, is LD 1915. That was the vote on intensive case management wage changes. The initial motion was ought not to pass, and that failed. The second motion was ought to pass as amended, and when we left the count, it was 6-5, yes to no. And I'm wondering from Karen whether we heard from our absent colleagues on LD 1915.
Yes, just pulling it up.
Sorry, I should have given you a heads up about that. I just want to close that out before the end of the week.
That's okay. That is okay. The final count, the vote closed today at noon. The final count is 7-5 with 1 absent.
Thank you. So my question of the 5 who voted against ought to pass as amended is the minority report.
That would be an ought not to pass.
Thank you very much.
Is that the one that we asked to send a letter?
That was in the initial motion, which failed.
Okay, so we can't send any letters as a.
You can send any letter you want, Representative Perry, but we don't, well, that was not part of the initial motion.
Okay.
Or the one we just finished voting on. It was a part of the initial, not part of the second motion. Well, any other thoughts, any other business to conduct? We just went through 10 bills. We didn't fix all of them. Senator Moore channeling me. So that's good work, people. We're doing all right, getting through our work, and I appreciate hanging in there day after day. So you can have tomorrow off as far as HHS. And I, if it doesn't get snowed out, we'll spend about 5 quality minutes with judiciary, getting permission to keep something quiet. All right. Any other business? Representative
Just a
Meyer?
motion to adjourn.
Any seconds?
Second.
Take care all.
Bye, everyone.